Hello there, welcome to the show. 2 channels here, now you know. Like and subscribe, it's all we need. Alternature or here to speak. And defense, let's take a peek. Collaborating for your eyes. Sharing content, no surprise. Together we shine brighter than one. Join our journey, it's just begun. Like and subscribe, hit that bell. Enjoy the show and wish us well.
Good morning. Jody's still dancing.
Morning.
Good morning, Gabby.
Hello, little one.
Hello, Christine.
Hey,
Hope you're
Christine.
doing well. Hope you had a good weekend.
Hey, Debbie.
There's
Flash.
Sharon. Good morning, Sharon.
No one remember that.
You challenging me today, Dill? Do you need a little boop?
Boop.
I can give him. I hand him out all day if I want to. Good morning, Debbie. Hey, Flash fan.
Does anyone remember that TV series that was called Flash?
The Flash?
Was it really like in the 80s and it used to go, Flash?
Yeah, Flash Gordon.
Doo-doo. Yes. Yes.
Yeah,
like
Flash Gordon.
Mention
Ever.
Gabby. So did I say hello to Sharon? Hello, Sharon.
I did.
Say hello to Christine.
I think we got everybody. If we missed you, I don't believe we did.
Welcome in. Now, we do realise that it's jury selection. We learnt from our previous Monday's mistake. Actually, that would be me. So, yes, we thought we'd just line up a few other things and have a bit of a chitty chat and, yeah.
Well, the trial that we're waiting to start is the Carly Gregg trial. It's in Mississippi. She is
Mississippi.
14, accused of unaliving her mother with 3 rounds to the face, I believe. Sending a text to her stepfather from her mother's phone to lure him home and waited to ambush him. But before she did that, she sent a text to her friend that there was an emergency and invited her over, or the friend over, and asked if she had ever seen a deceased body before. Also, while she was waiting for her friend to get there, she was outside playing with her dogs. Stepdad gets home. She fires 1 round into his shoulder. He's able to wrestle the weapon away from her.
Hey, Nidawow.
Good morning, Nidawow.
Now,
hope you are doing
was
well.
it the mum's pew-pew?
I don't know whose it was. I just know he was able to wrestle it away. And she then takes off, hops the fence, but she's hiding and watching as the police and everybody get there.
Yeah, she didn't get far.
She didn't get far. They got the helicopter up. I mean, if the helicopter finds you, I'm sorry, stop running. If you're running and you hear that sound over your head, they know where you are. So in the dark, in the day, they're following you. Stop. Just, Now, she supposedly had some mental health issues and had
Mm.
switched medications a
Only
week
a
prior
couple
to
of
this
weeks before.
happening.
Yep.
So
Which is
we've seen cases here, at least in the US, of young kids getting put on these antidepressants and then doing horrible things.
there's wisps is more of a bipolar disorder, though. I think I'm not sure if we've actually had a proper diagnosis, but I think there were along more the lines of bipolar, borderline personality type issues rather than. I'm sure there's probably anxiety and depression along with that, but that was the impression that I got. And the problem with that is the medication that you need for those types of things needs to build up and get to a therapeutic level in your system before it actually works. You can't just stop taking that stuff and change it.
Absolutely.
So whether she had adequate medical advice or control of these meds or what, I don't know. And then you add the Mary Jane factor into it.
Good morning, Alicia.
Oh, good morning,
It's
Elise.
not a good one. It's
Great,
for
great name. I love that
yeah,
name.
me too. It's
Named my
a,
daughter.
a trial about a 14-year-old girl who
Mm,
unalived her mother and then tried to unalive her stepfather. And she's in Mississippi. She's been charged as an adult.
yes, she's being
She's
held in an adult facility.
she's been in solitary confinement
Mhm.
and $1 million bond. Not like I don't think her stepdad was going to get her out anyway. I mean, and
Yeah.
I don't know where I don't know where the bio dad is. Um,
No,
he,
no, I don't know. I was actually going to ask that question, but
oh,
she
she
does.
does not have the best
What?
legal assistance. We were
Oh
talking
no,
about before stream.
no, no.
Um,
Yes, she yeah, I think ineffective counsel there, big time.
yeah.
But
And
mm,
Nidawa, you might know this better. I was trying to explain to Jody that in 2017, how our law changed that you could not sentence minors to life, but that there had to be some leeway there because we watched, um, gosh, I don't even know when we did it. It's been a while ago. We watched the Martise Fuller trial out of Florida or Wisconsin, and he was a minor when he committed the crime. That judge sentenced him to life, and they brought up that you couldn't, and she did not care, and I don't think the judge got that one wrong. That guy um, was doing a lot of stuff even in jail while he was waiting to go to trial and then go to prison. He was institutionalized like instantly. But I
mm,
know then they review them like every 20 in 25 years they would review her case. Um, so I'm not exactly sure exactly how that law, the Supreme Court changed that law, and I'm not a lawyer. I know it
yeah,
surprises all
no.
of you.
We were talking about this before stream because I thought I heard somewhere in one of the pre-trial motions that they were discussing. I think it might have been the plea deal where she turned down the 40-year plea. And I thought the judge had said, even though she was being tried as an adult, the sentence he was limited to for her as a juvenile, I think he could go between 20 to, to life. I think that's what I heard. But I I do believe they've altered the sentencing criteria for her to some extent, I think.
It, I don't. I don't think that one predated the decision, but I've watched them go back to juveniles that were sentenced to life because of that decision, and then they bring them back in front of a judge, and the judge can decide to resentence them. Some judges have set them free, um, but I don't
Hey,
think it
you
was
there?
that. I don't think it was that old. It was during COVID because the people were wearing masks.
Udahef
So
might know the answer to that one because he was talking about it in
good
chat.
morning.
We were talking about her sentencing and what her predicted, because we know she turned down the plea, and I thought that I'd heard somewhere the judge saying that he was going to restrict the sentencing from adult, like the 2 life sentences, to a more, I think he said, I'm sure he said 20 to life. Because that he was saying to her, you realise that doing this plea, you are then doing this, yeah? That's what you're at for. And I'd have to go back and find, but I've watched so many of the hearings, they've melded into one, and I can't remember where it.
It's like everything. It's you're kind of going, wait, I read this.
Yes, yes.
Wait, did they change it? Wait, did
I'm
they?
sure it was in the
Was it that case?
plea
Was it a
one.
different one? Like it's so. There's just so much information.
Yeah. But I thought we'd at least go through, we can at
Okay.
least go through something today, and I can have a look in the background whilst you're going through, and I'll see
All
if I can
the
find it.
oopsies. All the
Do you yeah,
documents
there you
are
go.
in my
I thought
Discord,
so.
Jody.
Sorry?
All the documents are in my Discord. There
Yes.
is a
Yep.
Carly Gregg thing in there.
Yeah, no, this wasn't a written thing. It was the judge speaking to her in a
Oh, I like this judge you'd have.
yes, he don't take nothing.
Yeah,
Yes. I thought
like
I'd seen it somewhere or
I
heard it
like
somewhere.
this judge. Well, yeah, I don't know what to do with her. Like, what do you do with her?
Mhm.
She's hard to watch because I'm like, are you really just not are you too yes, she is too young to understand the gravity of what she did and the long-term consequences of what she did. They don't have that ability.
Mm-mm.
But she also just kind of seems like she doesn't
Mm.
care.
Mhm.
And that's scary. Like that's kind of is she a psychopath? I mean, I'm not saying that in a bad like you psychopath. I'm not saying that. But is she like a psychopath? Is that
And
where she would be heading?
can she get a fair trial without these documents and evaluations coming in that have
I
been
don't know.
suppressed, you know?
I don't know. It's crazy.
Because she
Yeah.
really needs to be in the best place for her. And
Yep. He is. He is.
good.
I think he will be fair. I was telling Jody that judges
Mm.
don't want to see their trials get overturned on appeal. So I think he will be fair. Um, hopefully he will be fair to her as fair as he can be, but also you've got to hold people to do their
Still accountable.
jobs.
Yeah, yeah,
Like
yeah.
if you're supposed to have that in by this time, then
Mhm.
you should have it in.
And they were
So,
given plenty of warnings. It wasn't just a one-off.
yep. I'd say keep her in the hospital potentially for life.
Mm.
I don't disagree. She definitely needs mental health treatment.
I think there's a lot of that stuff behind a paywall, isn't there? We couldn't get hold of any of the reports or anything like that. It's just the basics paperwork
Yeah,
that we could,
I
yeah.
mean, with her being a minor, it's hard, and with her,
Yeah, I don't
um,
even think, the gavel drops had much.
with probably with
They said
HIPAA
it
and
was
stuff
they
like
even
that.
paid to get behind the paywall and couldn't access.
Yeah, yeah,
So,
her being a minor
yeah.
shuts off a lot of things. Yes, and I was explaining to Jody too. He will not be her lawyer on appeal because I will
Mhm.
be an appellate attorney, and they can come back and look at all the things he didn't do.
Who's the chick with the long brown hair that kept passing the yellow Post-it notes across her. She was
Probably.
being a pain. It was just like everything was Post-it at the defense table.
I don't know, probably co-counsel or his assistant or
Maybe.
paralegal, whatever they have sitting back there. It They should put
Okay.
her in youth jail. The Post-it lady.
Yeah.
I
Everything that the state said, they focused on the defense table, or they were focusing on Carly, and yeah, she just kept stretching across, giving Post-it notes to the guy. So she's got 2 attorneys, has she, Flash? Bridget Todd and the other guy.
They can't file anything on time.
Yeah, well, between the 2 of them, surely they could.
So, yeah, she'll have yeah. That's what I thought.
Absolutely.
She had the right attitude too.
Yeah.
I'm not sure. The Post-it lady? Kevin Camp. Flash is just
Oh,
in the
look at you
know.
go.
Flash is in the know. So
We made him mod. Why?
no,
He'd be a great help.
she was that's arresting. Well,
She was what?
RBF, resting bitch face.
Oh,
I
yes.
can't say
Yes.
anything about that because I have one of those myself.
No, you don't.
Oh, I do. Trust me. I know I do.
No, you
I have
don't.
had people call me out. Like, I'll be in a store shopping and somebody will see me that I know and they're like, "What's wrong with you?" Like, "Nothing. I'm shopping." "Well, you just look so unhappy." I'm like, "I'm just thinking. Sorry."
Ah, see, that's where Botox.
Oh, it's like, I just I guess I would have to just freeze it in a smile. Like,
No, you just do this bit here, the
I don't
frown.
get that. I don't get those. I don't get frown lines, but, uh, I just I
Frown.
guess when I'm concentrating, I'm just like, I'm just thinking about what I need. I don't wanna
Mm,
forget anything, and my mind is not looking for people I know.
mhm.
So, sorry.
Yeah.
Uh,
Go suck a lemon.
there's a reason for that, Brie. Yeah, you would think they wanna get this correct, but man, pull that dude off of there if he can't even file
Mhm.
on the time that he's supposed to. Alright. Kevin Camp is a DUI attorney,
Mm.
and Bridget Todd is a personal injury
Oh, well, that's
attorney.
great. They're really, really
Oh,
qualified.
well,
Yeah.
huh.
She's, in good hands.
I blame it on you being a Gemini all the time.
So who allocated them to her?
Uh,
The DA?
I don't know.
Dang nabbit, Mississippi, you done got that wrong.
Well, like, in some places, it's just whoever's up. Like, whatever there's you have all your public defenders or whatever, it's just whoever's up next gets the next trial. So, I don't
Is
know
there
how
not
they
levels of experience and stuff
I
that
have
you
no idea.
Mm,
'Cause Judge Simpson the other day had a woman who came in and she wanted to fire her public defender, and he allowed her to because her public defender hadn't done everything. She didn't even know she had a hearing that day. The public defender didn't tell her, and there were some other things going on, and he was furious. So he was like, "I don't know who's" I think he made the comment, "I don't know who's next up, but that's who you're getting." So she's off. Whoever's next up is on. So at least kind of that way gave me that sense of
mm.
they're assigned, and I don't know how they're assigned. Oh, they're private attorneys?
Are they?
Who's paying? Are they pro bono?
Mm. Yes, Sharon, it is. It is.
It is. There's nothing good that's going to come out of this. So if you see us
Being
laughing
silly.
or joking or being silly, it has nothing to do with the tragedy that happened in this
We're
case.
just trying to
Nothing
cope
at all.
ourselves.
Yes. And sometimes
Mhm.
you guys in chat just go off on something.
Sometimes I burst out laughing inappropriately when there's no one else can see anything, but the message in chat I've spotted hasn't come up on screen yet, so it
Yeah,
looks like I'm laughing at the attorney when I'm not.
yes, we're not
I really need to
ever
sync that better.
we're never laughing at the horribleness of what we're
No.
watching. We might poke fun at somebody, like, Jesus in the last trial.
Yes.
Um, but if we don't mean anything by it,
No.
so don't anybody get like offended. Just it gets
As
hard
long, as
watching
long
this
as no
stuff.
one says anything nasty to one another in chat, that's fine. We all look after each other here.
Absolutely. I
So in the US.
love all her knowledge. Some in the US,
Yeah.
if I can read. So in the US, some jurisdictions have public defender offices. Those people are government employees. Other jurisdictions have lists of private attorneys who take pro bono criminal cases. Awesome.
Okay. No spoilers, Flash.
That is true, Debbie, because I don't know what you've
Yeah.
watched of what Jody and I've done.
Yeah.
We didn't do it together, but the Jose Ruiz case, there is testimony out of
Mhm.
the closing arguments from the prosecution still are in my
Yep.
mind today.
Yep.
They painted such a picture of
Yep.
what that
The
girl went
thumb
through,
thumb touch. Mm.
and the video that we only heard the audio of her going through it
Mhm.
just doesn't leave you.
That
I
was my
don't
first trial.
that it was awful. Absolutely awful.
Yes, I'm on the mend, Sharon. Thank you. I spent the weekend lazing and grazing pretty much. Lots of carbs and lots of rest. And
Yes.
lots of baker, lots of broken baker. Don't know why it keeps coming up in my recommended.
That's not the one guy though that she's talking about that she only wants to see from the eyes
Oh, that was
That's the FBI dude.
Sharon knows who that is. Yeah. She even knows what the timestamp was
Ah, funny.
too.
Yeah, it was so bad, Debbie. It was so bad.
And the mother was just as bad,
Yep. Yeah.
if
Oh,
not worse.
Brie couldn't do it.
Yes, you've been in bed with me all weekend, Baker. I've been watching you
Baker,
stream.
naughty, naughty boy.
You rang.
You didn't even know. That's why you're so
He's
tired.
lurking. He's a lurker. Giggity. Oh, look what the cat dragged in. Morning, there.
Good morning, Adair. How you doing? And
Excellent. I'm glad to hear. Glad to hear. That
Glenn.
gives me a nickname, Glenn. Why is
Could be
that?
his real name. I don't know. In the latter situation, the jurisdiction pays the attorney's fees. That is usually pursuant to the statute of.
We
Hang on,
were
it goes.
trying to work out, Baker, whether or not the attorneys were private pro bono
Okay.
or public defenders. I thought they were
So
public
she's
defenders.
saying other jurisdictions have lists of private attorneys who take pro bono cases, and then and that jurisdiction pays the attorney's fees. Okay, got it.
One woman in every continent. Family guy. Oh, my.
Flashman, I don't know if they're picking up
Maybe they're just
or
becoming.
they're just because we have such access to
Mhm.
news and everything constant all the time that we're seeing it more. Instead of it just being a local case in Florida, now it's worldwide. If that makes sense, where we wouldn't have heard about it before.
Oh, okay.
Really?
Well, they're not getting very much value for money, are they? Just
Wow.
quietly. Mm.
I don't know what to say about that. Would
Mm.
you trust to have her in your home?
Mm-mm.
I mean, I understand it. I wouldn't want my child there either. But what do you do with her? Like,
No, the Sarah Burns attorneys are working for the attention, the
yeah,
publicity.
Sarah Boone's lawyers are working for fame,
Hmm.
hoping to get fortune.
Yeah.
Yeah. So we'll keep an eye out. I doubt they show jury selection.
Good morning, Kelly.
Good morning,
I
Kelly.
do
How you
believe I
doing?
saw you on Baker's Stream over the weekend too.
And we get to see Kelly. Look how pretty she is. And I took it down. Sorry.
You had your grandbabies up as your picture
She
on the
did.
weekend,
Yep.
didn't you? Yeah,
Last week.
thought so.
She doesn't look old enough to have grandbabies.
No,
Good for you.
neither do you.
Me?
Yes, you.
Thank you. Yes. Sarah Boone's coming up. Coming up quick. Everybody will be doing it. Like I said,
Yeah, it'll be a wham bam. Thank you, man.
I
When
mean,
it's over. Do 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 do.
there's well, 7th may be, because if you go 7th would be Friday. So that's maybe jury selection, 8th, 9th, and then 10th would be
Yeah,
Monday. So probably the 10th. Jury selection on the 7th.
depends if Sarah's allowed to be involved in the jury selection. How long it'll take?
I think, Baker, they should do openings. That's why I said Friday. Openings, show the video, closings,
Closings.
go to deliberation, verdict, and then we go to
Mm-hmm.
lunch.
Mm-hmm.
That's how quick I think it could go.
Mm-hmm.
She deserves a fair trial.
Mm-hmm.
But once you show the video,
It wasn't intentional.
oh, I guess you could show her saying that too, that it wasn't intentional,
Mm-hmm.
and that she's how smart she is.
Yep.
Like, it's just, it should not go on more than 2 days. That's what Jody said. 2 days.
Mm-hmm.
You keep saying that, Flash. I don't know if she has the dream team
Mm.
or I don't have a name for him. I don't know. I'm just wondering what is in these people's minds. That's what I said. If the suitcase doesn't fit, you must acquit.
The other
Sorry,
interesting
it
case
fit. Yes.
that I've got on my little docket somewhere is Lisa Cunningham. I don't know if you've all heard of her. I think it was Flash that actually mentioned her. She's the Aussie over in the US who is
Wow.
on trial, and she's up for the DP.
Is she in Arizona?
Remember, I think so. She's got something coming up this month. A hearing, I believe.
I believe that, Baker. Sarah
was
has a
that?
guy hoping to be Emily D. Baker, and the
Yeah.
rest is hoping for a book deal.
Uh-huh.
I agree with you and Kelly. Maybe they can make a movie. How not to get in a suitcase.
Well, how to get out of one.
How to get out of a suitcase. Oh yeah, you can't.
Friday. Friday is the is the hearing apparently for Lisa Cunningham. So that would be a good one to cover.
If
There's
they show
actually a
it,
couple of really good trials this week.
of course.
Yeah.
It always happens that way.
Yep. Yep.
But no, she does not. No, she does not. I'll tell you who did need him, though, was Ashley Benefield. If she would have had him or Diane Menashe, who did the Matt Moore trial, I think she would have fared better. Her attorney was not good.
I agree, Baker.
Yeah, but won't we all be disappointed if she does? I mean, let's be honest. We've all waited a very, very long time for this trial. And if she pleads that day, will we not all just be like, you'll hear just this worldwide scream that comes directly from YouTube of, are you kidding me?
Yeah. It would be a worldwide WTF day.
Oh, yes. You know, there's going to be, yes. Gabby, I think you and I discussed this Friday.
Oh,
That,
yes.
you know, especially if there's alcohol involved and there's a suitcase handy, people are going to
Awesome.
try it. Don't. Good. She needed one. Her lawyer was not good.
Yes. Yes. I hope,
I have to look at that.
well, weren't they going to dismiss they put in a motion to dismiss because of the prosecutorial misconduct of the two
Mean Girls.
bullying yes. Yes. They're supposed to present facts.
Yeah.
For justice, not to bully and harass.
Thank you,
And
Adair.
misinterpret.
Yes, they did.
He is a
And
lovely guy, yes.
he is very humble. It's very nice.
Also, funny AF as well.
My husband came home yesterday talking about seeing luggage on sale. Nope. We'll just take bags from now on.
What was it I quoted? Oh, I said Baker had the best description of Laurie Shaver as the glove.
Baker, I was going to send you a super chat and tell you that it was for when you found a new glove to fit in, but then I realized I really don't know your relationship status and you may not need a new glove. So I did not want to put that out there on your channel. I was there several times, like, just send it. And then I thought, wait a minute. What if he has a relationship? Doesn't need a glove.
That glove was cray-cray.
Yeah. You're a professional single, but you do need a glove.
Not one like that, though.
Do you want a mitten? Do you want one with fingers? Like, what do you want?
Hey, Jay.
Sorry.
Where's Carmen when you need her?
She's sleeping. She was an oven mitt. She could have been a catcher's mitt. She caught a lot. Caught a lot. Man, we are way off track already, aren't we?
Yes. Yes.
I have not been able to check to see if there's any feed up of.
I can check on YouTube
if they're going to do anything.
It's on Court TV, isn't it? If I remember right.
I thought it was Law Crime. Law Crime, maybe both.
Probably. I'll have a look.
I don't see anything on law and crime at this moment. WBLT.
Let's see. Live. No, nothing on Court TV either.
Can you check WBLT3?
WBLT3.
Oh, Gabby's driving.
Is that 3 wet bacon lettuce sandwiches? No? BLT?
I don't know. I like BLTs, but I never have the lettuce because my husband doesn't like lettuce.
In Jackson? Is that the one? WBLT3.
He said WBLT3 on your side.
Oh, I'm already subscribed.
I don't think she yells at you. Has she ever yelled at you? I never hear her say anything.
Who?
Jamie. And FYI, Gabby is driving.
Oh,
so be prepared. Or she's walking and there's turkeys chasing her. If there is no jury selection being shown, which I doubt there is.
Hang on. I've got an update.
Why are you yelling, Gabby? He can hear you even from there.
Yeah, I'll share this. Save me watching a whole lot. It's only a minute, so hang on. Move you up there and present. Share screen. This is a quick update that was like an hour ago. There you go. You can add that.
Make it
make it big.
Make it bigger.
Make it big. There you go. It's only
right.
a minute and 30.
Make sure you got your sound all good because I won't have any control.
Don't you control this? Or do I? Am I controlling it?
I believe that's you. I can't.
No, I just shared the screen with you. You're in control, baby.
I don't think I can hit play. Except for 10 a.m.
Oh, okay. I can hit play on here.
Is set to begin Monday in the trial of Carly Gregg, the now 15-year-old accused of killing her mother, Ashley Smiley, and shooting her stepfather, who survived. The shootings happening at a home in Brandon in March. Smiley was a teacher at Northwest Rankin High School. Months later, the teenager has made several court appearances, including one where she rejected a plea deal in August. Gregg will face a Rankin County judge once again, and for the first time in front of a jury, as her attorneys and state prosecutors make their cases.
Even just her outfits seem really like outdated. Like not.
I think
not
they're
suitable
just
for
trying to
her
make her
age.
look like she's at church. The little schoolgirl out, the little like Catholic school uniform outfit she had on in that one hearing.
I went to a Catholic schoolgirl and.
Well, I'm not saying they were pure.
Tuesday.
Oh God, no. Far from it, but yeah, no, wasn't anything like that.
Children of the Corn.
Circuit Court Judge Dewey Arthur issued a gag order that prevents attorneys from talking about the case to media. During a motion hearing that same day, attorneys for Gregg and prosecutors revealed a diary in discovery that allegedly belongs to Gregg's mother that could be used as evidence by the defense.
A diary.
During one of Gregg's court appearances in August, it was revealed that the then 14-year-old was receiving psychological help. The defense is expected to argue that her doctor had changed her medications a week prior to the shootings. Gregg has been held in solitary confinement in the Rankin County Jail since shortly after she was arrested.
No, yeah, you're right.
She's being tried as an adult and if convicted, faces up to 20 years to life. In Rankin County, Michaela Franklin, 16, WAPT News.
Thank you, Michaela.
Flash fan, Gabby is not scary at all. She is not scary at all. Baker, all I can think of when I see that is, he wants you too, Malachi. Because we watched that movie a ton when I was little, like in middle school, because we lived in Nebraska. I lived in Nebraska at the time, and it, took place in Nebraska. So that was at every slumber party. Your secret's out. You're not mean. I don't know, because it's going to be forever. Red Rum.
Right.
I just
They
watched
have-
that movie. Baker, I just watched The Shining. It's one of my favorite movies.
Oh, God, really?
I just watched it, not this weekend, but last weekend. I told my daughter-in-law, I was like, I can't wait to show this to to my granddaughter.
Mm.
I love that movie.
Right. So that is set to start at 12. 17th.
I should represent Sarah Boone. I don't think she'd like me.
Did you all see that? That's tomorrow. 17th.
Yeah, because it's a race. Yeah. That does.
So we may as well just go through the what was it? The competency? What was the one on
the one where they tried to get her moved to youth court.
Yes.
Sorry, I'm laughing at Flash Fan saying I should represent Sarah Boone.
Yeah. He's got a lot of knowledge. A lot.
Flash Fan, if I got up there and represented Sarah Boone, I would say, hey, y'all know she's guilty, right? Okay. The end.
Good morning, Candace. Welcome.
It's like, here's the suitcase. Can you get out? No? Okay.
Good. Bye.
The end again. Yeah, I don't think she'd like me. That's okay.
Would you lose sleep over it?
No. Like you said this morning, Jody, we're not everyone's cup of tea. And that's fine.
That's all right. I might.
Yes, she would. I would be an effective counsel. Most definitely. All right. I have the hearing from last week up. If you guys want to watch it, they were trying to get her moved from adult court down to youth court. I don't know. Nidwa, I don't know if you're still here or not. Because if she is found guilty, even though I know she's in adult jail right now, does she go to juvenile until she's 21 and then over to prison? Because that's sometimes what they do with minors who are convicted of crimes. I would have the shortest job ever as a lawyer. One trial, and then they'd be like, what are you doing here? I don't know. What the corn? There you go, Gabby.
That's the hearing that you covered. Was it Friday, Baker, with Jamie? That was a good one, I think. Yeah.
So she'd go straight to adult prison at 14. I don't agree with that at all. They will eat her alive,
Well, she'll stay in solitary.
or she'll stay in solitary, and then
Mhm.
she's gonna go more crazy than she is.
Yeah.
Wow. I don't like that. Flashman says when he did a web search, she'll be in youth lockup until she's 18.
Okay, Gabby.
Oh no, solitary will do her no good. That's where she's
No.
been since she was
Yeah.
arrested, and I'm sure it has hurt her. But Flashman, I don't believe that. The internet never, ever, ever lies. All right, I'm gonna take this down, Jody.
Yep. Have you got the
I have the
Jesus
other
hearing?
one. I do.
Awesome.
I do. Not sure how much I'll need to boost the sound. Make sure the CCs are on.
They actually got up to the podium and stood in front of a microphone in court, believe it or not.
Wow.
Yeah, imagine that.
I thought I was going to have to drive down to Florida and change the audio last week.
Yeah.
You know.
Mm.
All right, here we go.
Just do it.
I did, and then I forgot to share it.
I do that all the time. I can see it and hear it. I thought everyone else can.
It's like,
Because
what's
it's on a
wrong?
different screen.
I have it boosted. Flash fan, so hopefully we'll see. There's a lot of chatter that goes on before it ever starts. Make sure I have everything else turned back up. Sharon, I hope you get better soon.
Oh.
Fighting that. That's true, Nidawau, I forgot.
Mm.
I mean, he's another one. I'm glad he pled guilty just to not put the family through it because they had to go through enough with even doing that. But he will be institutionalized. He won't be able to. I don't see how he could ever come out into society again.
Yeah, this is the. Let's see if we can count how many post-it notes she passes. I swear. I swear.
Yeah, I thought it looked good. I haven't had time to watch it. I don't have it muted, so there we go.
No, it just hasn't started yet.
Excuse me, I was getting nervous. Sounds like I may need to turn it up more.
Yeah.
Oh, that's not me. Sorry, I was trying to move the happening.
We'll begin with docket number 168. The state filed a motion to limit to exclude motion of punishment. The defendant filed no response. Granted. Give me an order to that effect.
Yes, sir, Your Honor. One question regarding that punishment as well. The attempted murder statute requires bifurcation for guilt and sentencing. And of course, we would ask that any comments about sentencing be reserved for that, for the murder and the attempted
For
murder.
the sentencing things, yes.
Yes, sir.
All right, docket number 169, motion in limine to exclude golden rule and jury nullification arguments. No response was filed. It's granted. State's giving an order. All right, motion document number 170, motion in limine regarding facts not in evidence. No response was filed. Granted. Give me an order. Document number 171, motion in limine regarding speaking objections. No response was filed. Motion is granted. Document number 166, motion to suppress urine test. Heard from the state. I read the state's motion. Excuse me, I read the defense's motion. I read the state's response. State's burden of proof. Do you have any witnesses you wish to call?
I'm sorry, Your Honor.
It is the state's burden of proof. Does the state have any witnesses it wishes to call?
Sure, Your Honor. The state calls Corey Daubert.
All right.
I think is he the warden or someone in charge of?
What'd you say?
I think he's either the warden or someone in charge of like the admissions and screenings and stuff at the detention center where she's the adult place that she was at, because it's the urine screen was part of that transfer. Does that make sense?
Yes. He's Flashman says youth court prosecutor. I don't know. Sharon, no. This is where she unalived her mother and tried to unalive her stepfather.
Mm-hmm.
With a firearm
weapon
thingy. Pew pew. Dang it. I hate that
3
word.
extra large
Rounds.
I was just going to say piercings without the jewelry. Copper jewelry? Mm-hmm.
Yeah. Gauges.
Mm.
All right. Here we go.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
I do.
You have a chance, Your Honor, go ahead and answer this one. Answers up to I do. You may proceed.
If you would introduce yourself for the record.
My name is Corey Gerber.
And Mr. Gerber, what is your role currently?
I currently serve as the Rankin County Youth Court Prosecutor.
As a youth court prosecutor, do you have experience and information regarding what happens when an inmate is intaked at the juvenile detention facility?
I do.
And is there a policy and procedure put in place regarding drug screening of all offenders once they're taken into custody?
There is.
It is the practice of the juvenile detention center to drug test everybody that is brought in. That is my understanding.
And to be clear, could you explain for me kind of a breakdown out at the juvenile detention center? There is the youth part, the court part, of which you're a prosecutor, and then there is the detention part. Is that correct?
They're two separate entities. The juvenile detention center is run by the sheriff. The Rankin County Youth Court is the court, and they are separated by locked doors. We are two separate entities.
Hold on just a second. Okay. It's all right.
Testing.
Mr. Gerber, you said that each inmate is drug screened at admission. Could you tell the court what's the purpose of those drug screens?
My understanding is that every child detainee that is brought to the juvenile detention center is drug tested for the purposes of safety. There are multiple things that are done when a child is brought in. One, they are to meet with a mental health crisis assessor. The other is they are drug tested. And my understanding is that they are drug tested just to make sure that whatever substances are in their body for purposes of medical care.
And are you familiar with the drug screening that's done in conjunction with that?
I am.
Could you tell the court about that?
So those are observed screens. Those screens are taken. Once the screen is done, they are presented to the lab. Then the lab would run those tests. The lab is on site. That is a very expensive piece of machinery.
Which is a yogurt.
I'm an expert in how that machine is run. I can tell you that machine is calibrated once a week. Every time that the machine is started before any tests are run, there are controls that have to pass. You have 3 attempts to pass those controls. If the controls do not pass at that time, the machine has to be recalibrated until the controls do pass. Otherwise, we do not run tests.
And Mr. Gerber, do you have any personal knowledge about whether or not that machine was running appropriately on March the 20th of 2024?
I do not have any personal knowledge other than if it wasn't running appropriately, it would not have been running.
So they would not have performed a test if it was not working appropriately?
They would not have ran the test if it was not working appropriately.
You talked about that there's some checks and balances in place and calibration to make sure that the machine is running correctly. How reliable are the results from these particular drug screens?
They're very reliable. If they weren't reliable, we wouldn't use them. We wouldn't waste anybody's time or money doing the tests. I will say they are not confirmed tests. So typically what you have is whenever a urine test is had and you get a result, if that result is a positive test, what would typically happen in a case like that is that urine would be sent off for confirmation. We do not do that. We use that test primarily for assessment, not for any evidentiary value. We are not presenting that information to the court without some other types of discussion.
And so the screening's done for safety. The screening has some checks and balances in place. And you said that the results are very reliable. So if someone had presumed tested positive during one of those screens, like the defendant did in this case, that would be very reliable.
It would be reliable. If there was any question, typically what we would do is send that person for a separate test. Depending on what you're testing for is going to be a question. There are some things that we test for that are not as reliable as others. An example would be methamphetamines. Those are the ones that we typically have the question on. We do send those, we don't send that urine for confirmation. Instead, what we do is send the person out to give another test.
I know.
Court's indulgence.
That's all I could focus on the whole trial.
Mr. With
The whole hearing.
regards to the test performed by Carly Gregg, has anyone provided you anything to show that that particular test was not reliable?
I don't recall seeing that test, nor has anyone mentioned that it wouldn't be reliable.
No further question.
Thank you, Your Honor. Now, Corey, okay, why was Carly at the youth detention center to begin with?
Under federal statute, a child cannot be detained in an adult facility without an interest of justice hearing being had within 6 hours of that child being detained. So as a courtesy to the judge, Carly would have been at the juvenile detention center until a hearing could be scheduled for purposes of that interest of justice. She was there long enough for that hearing to be scheduled. She was transported from the juvenile detention center to the jail here or to the court. I'm not sure where she was sent after that, but that hearing was scheduled.
Okay, so, because she, according to the statute, she's considered an adult, correct?
Yes.
Okay. And so my understanding, why is it that everybody is tested in the youth detention center? Isn't there some federal grant that y'all are under that requires that?
I'm not certain whether there's a federal grant that requires everybody to be tested or not. Again, my understanding is they are tested out there for purposes of safety issues, safety reasons.
Okay, so she was only going to be held there for a few hours until she could be brought over here to Rankin County.
As soon as the hearing could be scheduled, correct.
Okay. And so there wasn't a warrant or anything like that to have her do this test, correct?
Not that I'm aware of.
And there was no probable cause where somebody was saying that we want this test done, correct?
Not certain. The only thing I can say is that she was tested for the same reasons that anybody else that would be brought to that detention center was tested for.
Okay. But she was an adult and everyone else would have been children, correct? Or youth. Okay, correct.
She would be classified as an adult. She's still a child.
Yes, I agree with you. She's still a child, but she would have been classified as adult.
Yes.
Okay. And so now when you were talking about the test itself, and you said that it's calibrated once a week. Okay. Is there like a logbook that you have that says that it's calibrated?
I don't calibrate it. I just know that the protocol of practice is that it is calibrated once a week, and that's going to be the first start, typically on Monday.
So you don't know if these things are even kept. Is that correct?
Oh, I don't know. I don't. I'm not the person running the machine.
Okay. And the night that this happened, who ran the machine?
I have no idea.
Okay. And if I showed you the test card, would you be able to tell us who ran the machine?
Yes.
Okay. Yeah, approach the witness, Your Honor.
Show the counsel. Anything we're going to show the witnesses.
No objection, Your Honor.
Can you mark that P1 for identification?
Yeah, that's the test card that we have. In fact, that's the only document that we have concerning this test.
This is the only document. There's no there's no back sheet to this.
That is the only document that we've been presented.
Then no, I can't tell you ran the test.
Okay. From looking at that document, can you even say that it's calibrated or it's been checked or anything?
I can't. Not from looking at this document, no.
Okay. Now, do you, I guess, once these samples, these samples are given, and you said they're taken to the lab, and the machine's in the lab, is that correct?
That's correct.
And then they're run at that, the samples run at that point.
It is run once the machine is started. So a better answer for your question is that if the sample is taken at night and it's placed in the lab would be started by the person that runs the machine when they would get there the next morning, and then it would be ran in. So I don't know what time this was taken. I can tell you the date that it was taken based on this. It was collected on the 20th, according to this sheet, and it would have been ran the same day at 9:21.
Okay. And when these samples are, I guess, run, what happens, I guess, is there going to be extra fluid? Or is it marked and then it's put in the, I guess you'll have a refrigerator or something?
So yes, that we do have a refrigerator, but no, the extra fluid is disposed of. We do not keep the urine, not to my knowledge.
Okay, so you run this test. So let's get back to this where you say you use the test for, because the test is for the youth court, basically. Is that correct?
Well, it depends on the case. I mean, yes. I mean, if this child were to be a child under the jurisdiction of the youth court, this test could be used for multiple things. One, to give the detention staff an idea of what is in that child's system for purposes of maintaining the child at the juvenile detention center. The second could be for purposes of disposition. The youth court is a court of rehabilitation. We want to address the whole child. So if I see this particular test, I can tell you that it's positive for cannabinoids in an amount of 237.7 nanograms per milliliter with a cutoff of B20. That would indicate that this child has consumed some type of cannabinoids. We would want to know that moving forward for purposes of A&D assessments and possibly enrolling them in some type of program to address cannabinoid use. If there is a question as to whether or not this is accurate, what would happen at that point is we would send that child for something else. But these tests are reliable, they're just not confirmed. So there is no, I would not use this as an evidentiary test.
Right, and that's what I'm getting at, is an evidentiary test to say that is actually what it is. That's not what you use them for, and that's not what they're designed to be used for, correct?
That's not what I use it for. Again, this is just an assessment tool used by the court for purposes of disposition. in the event that there's no contest between the child or the person, the donor. Sometimes adults get these tests. If there's no contest about what is found in these tests, at that point they can be submitted to the court. But I do not submit these to the court for evidentiary value and adjudication.
And so where we're at right now is, you said they're calibrated. There's no calibration documents or anything that I provided you or that you have in front of you, correct?
I don't have it, no. And you haven't provided it.
And I think the only thing I gave you is a test card that was given to us.
That's correct.
Okay. And so that doesn't tell who did the test. It doesn't say if the other safeguards have been done on the test. It doesn't.
Just
Yes,
like
ma'am.
that. Just like that.
Yes, ma'am. Thank you.
We'll even stop
Also-
the stream.
We have found the cure to Flash fans' hunger. Talk
Oh,
about urine.
oh. I told you about my funny urine thing when I was nursing, didn't I?
Oh, yes. I
Yes.
was like, yes. I was like,
Yeah.
you did? You did.
Mhm.
Well, I hope he ate it before we started watching this, Dill, because he's not hungry anymore. And that's the first time I've ever heard Flashman say he is not hungry. So, oh, that's about Gabby. And a lot of strudels. All righty. When the judge was going through that stuff at the very beginning about this motion was filed, there was no
No
response.
response.
Listen, we've all watched these trials. Attorneys like to talk a lot. I've never heard that. Just file something. That was crazy.
Mhm.
Nothing filed. Nothing filed.
Mhm.
Nothing filed.
So that
Granted,
means I'll be able to
granted.
do, what was it? Talking objections.
Good. Because I'm over sidebars. I want to hear it. Like,
Mhm.
sidebars. Like, no,
Sidebar.
I'll allow it. Speaking objections, put them out there. Also, this attorney stands like Mansfield, just so you know.
Yeah.
The back of him, he looks like Mr.
Yeah.
Mansfield.
Mhm.
Is the person even qualified who ran the test? We don't even know that, do we?
I will tell you that there are only
It's a
certain
screening
people that are
test,
allowed to
mate.
touch
Get
that
over it.
very expensive machine. They are all qualified to run it. But I
He's trying to say they didn't calibrate. Like, how do you know they calibrated the
Yep.
machine? There's no record of them
Yep.
calibrating the machine.
Yep.
Blah, 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 blah.
Yep. Hey,
Good
Zach.
morning, Zach. Happy Monday to you. You are doing well. No, are you guys getting rain yet? Storm things, the hurricanes that keep coming in. I don't know where you are in Texas, because Texas is a big state.
I'm just reading Gabby's
Toaster
frosting
strudel.
doodle on my strudel.
Toaster strudel, you look so good. And yummy toaster strudel, get in my tummy. Frosting doodle on my strudel. And now I'm going to eat you up.
Okay.
I thought you wrote a poem.
Can I have what she's having?
Don't tell Mr. Hamp that. No rain. Awesome. Well, it's good to see you, Zach. I will let our daughter know you were here. When I see her, I think she's sleeping. All right, back to this fantastic lawyering.
can't tell you who did that particular day. As to your other question,
Sorry.
it was selected by.
Just kidding. I wondered how you were going to Alex Jones me, and you did it.
Mm.
Thanks.
Mhm.
I'll have to explain later, Jody.
Mhm.
I will tell her. I will tell her. She's going to be here next month. So
Well, that was a surprise, was it? That's what she was talking about. I'll see you soon.
yep,
Figured as
she will
much.
be here around the 20th of October for
Yay!
that week. So she's finally gonna get to meet Super Baby and just be here for a visit for a little bit. They're all going to I don't like haunted houses, so they're all going to this thing called the 13th hour. It's got like 4 haunted houses in it. Some are
Cool.
outside and inside, and it's
I love
very
that stuff.
it's not interactive as in they do anything to you, but so I said I will stay with the baby because I hate haunted houses. You guys go. I could work in a haunted house. I would love. I don't mind scaring people, but don't scare me. That's not fair. That's my rule. So she's coming up, and my husband and Bill, Super Son, and Carmen all going to the haunted house, and I'm staying with the baby.
Is Shay not coming?
No, so um I would. uh so Carmen gets back Sunday, and then Cheyenne leaves for California on Tuesday, and she starts her residency out there. So she might actually get to see Chrissy. We got to remind Chrissy that she's coming. I'm glad I'm not alone, Candace. Thank you
Hey,
very much.
Candace. I went on a haunted tour of Port Arthur in Tasmania. Went on my honeymoon. It's
Nice.
great. It was awesome.
Yeah. Well, the last haunted house, let's see, we went through a haunted house once, and my husband was behind me, so he had a hold of my hand. And then all of a sudden, he didn't have a hold of my hand.
Mhm.
And I turned around. It's because they were trying to put one of the people that was working in the haunted house behind me. So I was like, "Do you think I'm that dumb?" Like, and then the next time the next haunted house we went into, I wanted to go in behind him, and he wouldn't let me. So I had to go I had to go through every room first. I was like, "I'm not doing that again."
Yes, Amanda, it most definitely is Mississippi.
Yes. Yep.
And welcome.
And yes, welcome. I would get you back, Flash Fan. I would, I promise. I'm good at that.
This is pre-trial hearing though, Amanda. The trial starts tomorrow, I believe. They're doing jury selection today.
Yes. Hopefully they don't. Well, I mean, even if they sneak it in on us in this afternoon, we'll just do it tomorrow morning. So, like they did last time.
Like the verdict for Laurie Shaver.
Still mad at myself.
Welcome
You
from
don't sound
Georgia,
that sorry.
Alabama. I'm from Melbourne, Australia.
Hey,
G'day.
I'm in Indiana, and I was in California in a store, and the guy working asked me where I was from, and I told him Indiana, and he said, "Yeah, that's not South." And I was like, "Don't tell them that." You go to Kentucky, holy crap, do they have an accent? Even worse than this, I don't know.
We just had a trial in Kentucky, didn't we? 3.5 hours approximately.
Yeah, it was like 3 hours and 45 minutes. Did you really do that? You punched one of the actors. was thinking mum, like Jody would say, M-U-M for mom.
Mom, 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 mom.
Yeah, 164 hours. Oh, that's hilarious, Zach. And I can absolutely 100% see you doing it. You were born in Georgia and taken across the state line in Alabama. That's why I claim them both. Awesome. I'm from Indiana and Nebraska.
Good morning, girl,
Teresa.
Ryan.
Oh,
Good morning, Teresa. Look at you
good
all.
morning. You're from Central Kentucky and live in North Carolina now. People tell me here I'm a Yankee, and I'm like, have you heard
Yankee.
our accent? Yes, girl, Ryan. I have a friend from high school that moved from Indiana to Kentucky, and I went to see her, and she called me like, "Who is this?" Because she did not sound like that when she left here. I mean, yeah, Kentucky, man, they have some.
It's funny, every state in Australia, we all sound the same.
Apparently, yes, Flashman, they do. Because when I went back to Nebraska for the first, like after I'd been here for a while and visited some of my friends, they all laughed at me, and I asked what they were laughing at, and they said, "You talk funny." Like, what do I? They said, "You say talk 2 and 10 funny." I'm like, I don't either. So these people here in Indiana think I have a weird Nebraska accent, and Nebraska thinks I have a weird Indiana accent. So I don't know what I have. I'm a mutt.
Okay. I was actually born in Bethlehem Hospital in Melbourne. See that halo?
I see it. I see it. We have weird. Yeah. I don't know.
Really?
Yeah, there is a difference. I agree with her. And
Well, if
people
you're
in
talking
Australia.
about Aussie Insider, she's Kiwi. I had to tell you that's a Kiwi accent.
Is that New Zealand?
Mm-hmm.
They definitely different than yours. I have a Mississippi accent. I'm from Seattle and live in Tennessee. I've been told I talk funny, but I'm pretty cool for a Yankee. I have been told I have an accent from the northwest part of the country too, and I've never been there. So I don't know where I would have picked it up. Ohio people have an accent? They do? Huh.
A piece of fruit.
She did not. No.
Oh, Kiwi. No.
All right. We all have accents and talk funny.
Mm-hmm. Yeah.
Oh, case solved. Back to this.
I'll give any one of them a go.
Back to this thing, trying to discredit him. Oh, I can't try. Bree, stop it.
Someone in the Rankin County Sheriff's Department. So that would be a detention staff, but I do not know who that would have been. That information can be gathered, but I don't have it.
No further questions, Chairman.
Can I read the exhibit with my court reporter?
Yes. I'm trying to steal your exhibits.
Mr.
Gerber, as I understood it on cross-examination, you said these tests are for, again, safety and medical purposes for the detention staff as well as the donor.
As well as disposition. In the adult world, that would be sentencing. We want to make sure that we have all the information available to us to make sure that the rehabilitation process happens. So they have multiple uses, yes.
When the detention center finds someone is tested positive for a substance like Ms. Gregg did in this case, why is that important for them to know from a safety standpoint?
Well, for example, if it had been fentanyl, we would have taken the child directly to the hospital. The other is we want to make sure that there's no interaction with anything else that's going on. I don't work in the detention center. I don't want to speak for them, but I mean, I think it's fairly obvious that we want to know if the child is under the influence of any type of drug while they're in the detention center.
And if the child
That
admits
stands for
that they use
automobile
drugs,
insane.
would that tend to corroborate the test results as well?
Yes.
Do you have any information that Ms. Gregg did not corroborate this test? Did you sit here today?
No, she's a
No,
fairy.
I don't have any information.
No further questions, Your Honor.
Stand down. State may call its next witness.
No further witness, just the argument, Your Honor.
Defense have any witnesses that wishes to call on this issue?
No, Your Honor.
All right, argument by the state.
Yep.
From here, the vote, Your Honor.
Zach, that's lies. All lies. My daughter's just been there almost a year and she's already picked it up. So has Indiana and Texas accent. Oh my goodness. Take your swine. That was a sad trial. I'm sorry.
The state outlined in our response and then filed an amended response. I want to bring that to the court's attention. Initially, we believed that the Juvenile Detention Center was under a particular grant through the OJJDP, which is the Office of Juvenile Justice and Delinquency Prevention, that federal grant does require drug testing. Upon communications with the Board of Supervisors, it's actually a different grant than we initially cited in our response. So I did file an amended response attaching the appropriate grant that does in fact require drug screens of all offenders at entry. Or that does require, drug screens, as well as the Rankin County Sheriff Department's Juvenile Detention Center Policies and Procedures 2.2F. Those were provided to me by the Sheriff's Department, which again outlined that each offender is screened there at the detention center immediately. It also outlines the policies and procedures that are to take place upon entry. These screens, as you heard from Mr. Gerber, are very reliable. The state is not attempting to use this screen for quantification, rather for presumption. As pointed out in our response, the defendant has admitted during particular evaluations and through other witnesses that she did in fact use marijuana. She has said that she used it during her assessment with Region 8 as well. She says that she smoked it. This happened on the 19th. She says that she smoked it on the 18th at least. We believe that this information is certainly pertinent since she has asserted her right to claim an insanity defense. As this court's well aware, in cases such as Crawford v. State, once the defendant puts their sanity at issue, the door is thrown wide open for the admission of evidence of every act of the accused's life relevant to the issue of insanity or sanity and is admissible in evidence. That's Crawford v. State, 867 Southern 2nd, 196. Additionally, Mississippi Rules of Evidence 703 state that an expert can rely on facts and data that are not necessarily admissible in evidence. And so our doctor, Dr. Pickett, has relied upon Carly's admissions of using marijuana as well as this presumptive test to show that is and does call into question her mental state. As this court is also aware, voluntary intoxication is not a defense to murder. It does not entitle you to an insanity defense. And so we believe that 703 as well as Crawford and the admissions by the defendant make this test even more reliable. This isn't just a piece of paper that shows that she had marijuana in her system. We have the defendant herself saying that she'd smoked marijuana at or around the time of the crime, as well as additional witnesses that we intend to introduce. As outlined in our arguments, we also believe that this urine screen is akin to the DNA buccal swab found in Maryland v. King. There was a 3-part test. We believe that it's similar in that the Rankin County Detention Center's booking policies require that all offenders be screened, that urine, and also that urine sample is the least and minimally invasive drug screen that's available to them at the time. And as such, we believe that the drug screen itself should be admissible under Maryland v. King. Also is cited in our arguments, and what Mr. Gerber talked about today was that these tests are done for the safety of both the offender as well as the facility. And we believe that that record is actually a part of Carly Gregg's medical records. And because of that, and because of her claim of insanity, she has waived all medical privilege with regards to anything that might have to do with her mental state at the time of the crime. Specifically, we cite to Rule 503F of the Mississippi Rules of Evidence, as well as the cases outlined in our response.
You're muted. Dang it. I can lip read. She said, dang it.
I was trying to be nice. Girl Ryan, in case you couldn't hear Jody, because I can't hear her, so I don't know how well you guys can. I just have the court feed in my ears. It's in Mississippi. That's all I was trying to say.
Yeah.
Yes,
Yeah.
I did say it.
And Adair, gourd is not an aggressive word. Like, it's not a bad word. It's not
No,
stupid.
he said
I
I'm
know.
alive.
No.
Yes. I was so proud of him too. Adair, you feel about that word as I feel about pew pew. Because I hate that word. So, you're welcome. Sorry I was muted and wasted time. All right. Back to this. Also, I want to cut her bangs.
Yes.
Just pin them over. Get them out of her face. I hope not. Good grief.
We ask that the state be allowed, that our evaluating psychiatrists be allowed to review and talk about the results from this urine screen as they do affect the defendant's mental state at the time of the crime. And then additionally, we would argue that if a search warrant was required, Holloman v. State would apply. In this case, it was a drunk driver who killed someone driving in a car. Law enforcement was on the scene. They observed the presence of beer cans, empty syringes, and bottles containing unidentified liquids. At the time, the person's blood was drawn, and also a urine sample was taken. There was the presence of methamphetamines and cocaine. This sample was taken without a warrant, similar to what we have here, and the court found that a warrantless search is permissible in certain exigent circumstances if it can be shown that grounds existed to conduct the search that, had time permitted, would reasonably have satisfied a disinterested magistrate that a warrant should be properly issued. And similar to Holloman in this case, the substances that were in Ms. Gregg's system at the time can dissipate over a period of time. And this screen was done on the 20th. She was brought over hours later. And we would argue, Your Honor, that if a warrant was got, if we had received a warrant, had to serve it on her and get an additional sample, that would be even more far removed than this sample was on the 20th rather than the 19th at the time of the crime. We would, of course, also state that, as pointed out, it's going to come into evidence that Ms. Gregg was using marijuana. And we believe that if it doesn't fall under the warrantless search and for the safety and within her medical records, and the alternative, the state would argue that this would fall in the inevitable discovery doctrine. And admittedly, under that doctrine, you have to show that law enforcement, there was some misconduct, and that but for the misconduct, these items would have come forward. There's been no such misconduct in this case. However, there is a test that outlines when things would come into play if it was inevitably discovered. And we believe that's the same thing with a urine screen. Based on admissions by the defendant as well as other evidence, law enforcement had at the time in their possession illegal substances, the presence of the vape pens that they had seized from the house, and knew of the fact that there may be a potential for drugs to be in her system. We would certainly ask Your Honor to consider all of those exceptions and rule that the urine screen would be admissible for its purpose of showing that marijuana was in fact in her system and not for a quantitative state.
Response.
Thank you. First of all, y'all, I'm just going to briefly touch base. The state brought up the fact of basically the indigent circumstance where you can draw blood. The Supreme Court of the United States changed that in McNeely, Missouri versus McNeely in 2013. You now have to have a warrant. So when the state's saying that you do not have to have a warrant in that type, like in the hallway situation, that was a different time. That was okay at that time. That would have been under the Shoemaker ruling, that said that there were exigent circumstances and that you could get away with not having a warrant. That has now changed. The one thing I want to say is that with this charge, Carly was charged as an adult, and she was taken to the youth detention center, and it puts her in a different status than most people that are going to the youth detention center. Most of the people that are going to the youth detention center are being handled as youth. In fact, I would say all of them except a very small, minute amount. In Carly's situation, she's entitled to due process, which is there has to be a warrant, there has to be probable cause, there has to be some of the protections built in. They bring up the Maryland v. King case, and they say, well, in Maryland v. King, there was actually a state statute that mandated certain testing. And the Supreme Court was looking to see if that was viable, if that was a viable law. And they came back and they said, yes, if there was it validated the law. It said that there was a judicial reason for them to have the law, to have the testing. So therefore, what they did in Maryland versus King was okay. That's not the type of situation that we have here. There is no Mississippi law. There is no federal law that says that this shall be done. This is just the policy and procedure of the Rankin County Detention Center. And so what's happened is she's entitled to due process, and that didn't happen in this situation. There is no probable cause. There is no warrant. That was testified from the stand. And the next thing that I want to bring up and put to the attention of the court, in order for a test to be valid, you have to have the person, and this is under Mississippi law, and this is any of these chemical tests, you have to know who the person is performing the test. You have to know the testing procedures. It has to be laid out somehow, and it has to be presented to the court and say, hey, this is done. And then the last thing is there has to be something to show that it's reliable. The way they show that it's reliable is having calibration records. You have the information of who did the test, how it was done, when it was done, and it was done according to the way the test was supposed to be carried out. We don't have any of that. The only thing that has been presented to us is a one-page paper, and on the bottom of the paper, it's document 1 of 1. It's not 1 of 10 or something like. There's a whole bunch of other documents that go with it. You have a test card. The other thing that comes into play is the state is wanting. They say, first of all, the test is not designed to be a standalone test. It is not to say what you're seeing in that test is what's in her system. It's only an identification test. They use it for that purpose. They do not use it for evidentiary purposes. What the state's wanting to do is take that test and then turn it into evidentiary purposes. They say, well, we just want to have it as like an identification kind of thing. Well, no, they're wanting to, in their reports, they're going in and trying to say whether or not she's under the influence at the time based upon that test, which is an invalid test. It does not show, it doesn't meet any of the requirements of being a valid test at the, by how it was done, who did it, was it calibrated, did they follow the protocols? None of that stuff. None of it has been provided to us. And also, there's been no consent, there's been no testimony that there's no consent, there's no warrant, the test wasn't done right, it's being used for a different purpose than what the youth detention center uses it for. For all those reasons, Your Honor, we ask that the test be excluded at this time.
Mr. Mackey, any reply?
Yes, sir.
Nothing yet, Elizabeth.
Elizabeth, you haven't missed anything. We're just watching a hearing from last week. We're doing jury selection today, so nothing has started in the actual trial. I think you're gonna hear a lot of bad lawyering, but you haven't missed any so far. She does look like a preschooler, just got recess taken away. I don't know if she's medicated or not. It wouldn't surprise me if she was. And it wouldn't surprise me if just being in solitary confinement has messed with her head.
Yeah.
Like it does. So I don't know. But I'd say it's possible she's medicated. Not a doctor. Just a guess.
I believe that Missouri versus McNeely deals with warrants for blood draws, and in this case, we're talking about a urine screen. Also, Mr.
morning,
Camp
Ronnie.
mentions the laws in Mississippi.
Hey, Ronnie. Haven't seen you in a long, long time. How you doing? Hope you are doing well. Dara's going to be like, Ronnie, what's up?
Mississippi in the statutes about calibration, and I believe what he's referencing to is the implied consent law, which talks about intoxilizers, not the drug urine screens. Again, we believe that this does fall within the exceptions as cited in our amended response and also argued today. And more importantly, we believe that it falls within Ms. Gregg's medical records upon which she's waived any privilege to, as well as under Rule 703, and that our experts should be allowed to rely upon the presence of marijuana in her system at or near the time of the crime, including the day after the offense, to render his opinions regarding her mental state at the time. We ask that the urine drug screen not be suppressed in its entirety, Your Honor.
Hold that for a little bowl of amber liquid.
The court looked at several different cases, in particular Skinner, Von Rath, Vernonia, Maryland versus King. In addition, the court also read Chandler versus Miller, Ferguson versus City of Charleston. In this particular case, because the need for a warrant is greatly diminished here, where the arrestee was already in valid police custody for a serious offense, supported by probable cause, the search is analyzed by reference to reasonableness, not individualized suspicion. Reasonableness is determined by weighing the promotion of a legitimate governmental interest against the degree to which the search intrudes upon an individual's privacy. The court would find that the government has there's a legitimate governmental interest in determining whether or not somebody is under the influence in the juvenile detention center, not for the purposes of prosecution, but for the purposes of safety of the accused. Obviously, like Mr. Gerber testified, if somebody tested positive for fentanyl, there's serious withdrawal issues. Well documented. It's not hard to find that out there. I'm not sure the juvenile detention center is equipped to handle those type of situations. There's a valid governmental reason to do it. Looking at Skinner, Von Rath, and Vernonia, the court believes that falls into that. Additionally, the court looked at Jones versus State, Mississippi case cited 881 Southern 2nd 209. The physician-patient privilege was waived in this particular case. And in Jones, the evidence was actually used to prosecute the person. That was not the intent of this evidence. The intent of this evidence was to find out whether or not there was a critical medical need that needed to be assessed at that moment. Now, the court would have a different holding if the state was attempting to offer this to prove possession of cannabinoids or some other crime, but that's not what it's being offered for. In retrospect, the state was able to go back and look at that and raise it for the defendant's insanity defense. So for those reasons, in the case law cited, Maryland versus King, the court would also find that a urine analysis is the least invasive and most reliable method to obtain a drug screen. A needle would be very invasive. Buccal swabs are not considered to be very reliable. The saliva type testing. Hair testing is invasive. You're retrieving a piece of hair from the child's body. And in addition, the reliability of those in short periods of time are not where they need to be, so to speak. It shows too great of a window. So for those reasons, the court is going to deny the motion to suppress. However, the court is going to restrict the state. You're not to get into this in your case in chief. It can only be used if and when the defendant raises their insanity defense. That'll be the court's rule of states to give me an order. All right. Next matter was a motion for gag order document number 177. The response was filed late. As such, it will not be considered. Motion for gag order is granted. Give me an order. Next motion is document number 175. Motion to enforce.
Did you see Post-it Note's face when he said it won't be heard? She's like, yeah, you filed late.
Mm-hmm.
Oops.
Yep.
Oh, it does? Oh, wow.
Hmm. Hmm. Hmm.
Not surprising.
No.
Probably correct.
Yeah.
And the reading of the verdict and the reaction was about as boring as the trial was.
Yeah. Yeah.
That's
They
what
could
I
have
thought
squished
about
all that into one day, I reckon.
it. Yeah.
Mm,
Yep.
I don't know. Yeah.
It just was so anticlimactic, I guess. I don't I mean, like, I don't know what I expected. They said she cried. I didn't see her, like, she wasn't
No.
bawling. Not like she tried to do on the stand.
Mm-hmm.
But yeah. So, all right. Back to this bad
Yeah.
lawyering.
Yeah.
Previous orders and compel a motion to eliminate to exclude evidence not previously discovered, produced and discovered. Again, the response was filed late. Document number 174, motion to eliminate to exclude insanity defense, exclude testimony of Dr. Gerald O'Brien, Dr. Mark Webb, and Dr. Clark. Again, there was a late response filed. However, we're going to have to deal with the issue of late file discovery. So I won't hear it all at once. State's motion, I'll hear you out.
Court's indulgence, I'm trying to get it.
Mm.
Well, she's getting that together. For the record, even though the responses were filed late and the others, I did read them before I granted the motion. All right, you can see.
And I'll start with our, I guess, Motion to enforce the court's previous orders to compel and motion limited to exclude evidence not previously produced in discovery. This court entered an order directing both parties to exchange discovery that was in their possession at that time by August the 20th, 2024.
I think I actually worked on it 2-3 times before.
That's correct, Aaron. The last order regarding discovery said that all discovery within the party's possession, there was also an in-court hearing regarding that, was to be turned over or the possibility that be excluded.
All right, let's go.
So
What are you trying to exclude? Which witnesses?
yes, sir, Your Honor. So as of August the 20th, 2024, the state had 0 witnesses from the defendant and or any substance of their testimony. So we filed this motion on August the 30th, asking that pretty much any evidence that they sought to introduce at that point be excluded because we have received none. So to be clear, the defendant had dropped off an external hard drive, a jump drive at our office. It contained photographs. It contained an investigative journal by someone by the name of Amber Floyd. It did not contain anyone's testimony, anyone's information, and we were not provided the substance of anyone's testimony. During that same meeting, this was plea negotiations. The state had offered and asked, quite frankly begged, for the names of anyone who would provide any information regarding the defendant's potential mental state at the time. We were not provided that information. However, the defense attorneys told us during that meeting that they knew the names of several teachers, as well as had a statement that the victim, the living victim in this case, Heath Smiley, had prepared, where they had sent him questions and he responded to those questions in writing, as well as other witnesses. We asked that that be turned over on that day. It was not. We've asked that it be turned over subsequent to that, and it was not until September the 3rd that the state received a list of witnesses from the defendant.
How you doing, Lockong Express? I like when you just pop in every so often. It's good to see you. And yes, banjos. If a banjo could talk, not as bad as Gravely. Although her attorney might be up there.
Hey, Lockong Express.
Yeah.
Welcome.
Welcome.
We got lots of lots of lots of them.
All right, back to bad lawyering.
And then, and I apologize, Judge, may I get that?
You have a copy of it?
Yes, sir.
Of the list you received.
Yes, sir, Your Honor. On September the 3rd, the state was emailed a witness list that contained the name of Heath Smiley, stating that his proposed testimony would regard his personal knowledge and observation of the events on March the 19th, 2024, his relationship with Carly's mother, Carly's relationship with Heath, Ashley Smiley's mental and physical state, which we've been provided no documents to that effect, Carly's behavior and mental health issues from the fall of 2023 through the present. At this point, we still have not been provided any documentation, any statements, anything regarding any mental state other than the records that we've requested from 2023 outside of Mr. Smiley's interview with law enforcement on April the 4th that we provided. Additionally, it says that he will talk about the investigation in this matter by the Sheriff's Department as well as the Rankin County District Attorney's Office. Essentially, Vicki Breland has pretty much the exact same substance of testimony. That is the deceased victim, Ashley Smiley's mother. Next witness is James Daniel Floyd. He is the brother-in-law of the deceased victim, Ashley Smiley. We have no substance of his testimony other than he will testify regarding his personal knowledge and observations regarding the events on March the 19th, 2024, and the investigation by the Rankin County Sheriff's Office. No information provided by him other than that, with the exception of contact information. BG, who the state has interviewed, and SR, who the state has interviewed. Next, they list a Shira Higby. It is believed that Ms. Higbee is a teacher and that this is one of the individuals, again, that the defendant knew about far in advance of August the 20th, as well as Tricia Gilbreth. Again, it appears to be a teacher of Carly's that the defendant knew about far in advance of August the 20th. They next name Dr. Andrew Clark, which he was not retained before August the 20th. So of course that was not in their possession at the time. We have a separate motion regarding Mr. Clark. And then Corey Garber, which we do not object, of course, to the testimony that he provided. But certainly, so we're asking that any testimony that Mr. Smiley is called to testify about outside of the two statements that he's provided to law enforcement in this case be excluded. We ask that any testimony by Vicki Breland regarding anything at all be excluded, that the testimony of James Daniel Floyd regarding any type of testimony be excluded, that BG, anything outside of the interviews that he's provided to our office be excluded, and those have been turned over to the defense, as well as SR. Same thing for her. Our office provided statements to them, recorded and typed up interview notes. And then we're asking that Sherry Higbee, Tricia Gilbreth be excluded. And of course, we asked separately that Dr. Andrew Clark be excluded. But those were all people that were in the possession of the defendant prior to August the 20th, 24. In addition to,
Do you have a copy of the witness list?
yes, sir. May I approach? And Your Honor, for the record, I want to show it to them. I have the email where it was sent September the 3rd at 4:15 to our office. May I proceed? We, of course, outlined our arguments within our motion as to why we believe that those witnesses should be excluded. I mean, first and foremost, the fact that they violated this court's multiple orders regarding discovery, that by their own admission, they had this information and for whatever reason chose to wait till September the 3rd to produce it. There's no good reason other than willful conduct for them to have done such. Where there were multiple conversations between the state and the defense about turning over this information. This is not new information. This is not something that wasn't in their possession. This is something that we certainly believe is akin to a willful attempt to hide evidence. We ask that each of those witnesses, with the exception of Mr. Smiley, and the testimony that he's previously provided to law enforcement, be excluded. Would the court like for me to proceed with regards to our other motion in limine for the experts?
No. Any further argument as to these witnesses?
No, sir.
I'll hear the response.
You know, we provided the state a witness list. I think it was sent over on the 3rd of September, if I remember, and I think that's what it was told to the court. I don't think the state is saying that they're surprised as far as any of the witnesses. I think what they're asking for is for the witnesses to be struck. I have brought some case law dealing with that issue for the court, if I may approach, Your Honor.
I'd like to see your case law.
Dealing with when we're talking about witnesses being struck and everything, Your Honor, the issue of witnesses not being allowed to be used, it gets into the issue of surprise, whether or not the other side is being surprised. Most of the time, in all the case law, it is either in the middle of trial when that's taking place, or right on the eve of trial.
What about Page versus State?
Again, Your Honor, I'm not familiar with Page versus
Page
State.
versus State was 11 days before trial. The defendant provided a list of witnesses, but did not provide the substance of their testimony. He made the exact same argument that you've made before this court in regards to an affirmative defense of alibi. And the Supreme Court said the court was right to strike it down and exclude it.
Well, my understanding following in looking at the case law as far as, I guess, what has been provided and everything, most of the witnesses that we have are witnesses that we have gotten from the state.
Okay, the Supreme Court's also dealt with that. There is no exception. Under the defendant's requirement to disclose witnesses in Davis versus State, 9.04C1 clearly requires the defendant to disclose the names and addresses of all witnesses in chief, which the defendant may offer at trial, together with a copy of any written or recorded statement or oral statement they were aware of, and the substance of any oral statement. The rule contains no exception for a witness who is referenced in materials that the state produced in discovery. So I will start here. Show this your burden of proof. Show me what you produced as to Heath Smiley.
We don't have any written statements from Heath Smiley.
Did he give you any oral statements?
Just what the same thing that he's given to both sides. I mean, that's the.
Great, so all he'll be able to testify to is what was provided in the state's discovery, correct?
That's correct, Your Honor.
Okay, so he'll not be testifying to anything other than what he's testified to in open court or what he's given a statement on.
That's correct.
Okay. All right, that was pretty easy. Vicky Breeden, show me what you produced.
I think it's what has been proved. Has there been anything?
What's in the witness list?
It's what's on the witness list, Your Honor. There were no written statements from her.
It's not just written statements.
There was no.
You practiced law here for 20 years. You know this. You know this. They told you something, you have to turn it over. So if Vicky Breeden said, hey, I knew A, B, C, D, she doesn't necessarily have to write it down. You have to tell them about it. Y'all show me what you produced. Is there anything else that you produced other than what's on S1?
No.
James Daniel Ford. Show me what was produced other than James Daniel Ford.
It would be the same, Your Honor. There's no written statements or anything. It'd be.
What about oral statements? Did he give an oral statement that would be relevant?
I'm sorry. Your Honor, Dr. Clark talked to Heath Smiley, and that is in Dr. Clark's room. So that has been furnished.
When? What day was that furnished?
On the 6th, I believe, Your Honor. September 6th.
17 days after the fourth discovery deadline before then?
Yeah, it wasn't a conversation I had with Heath Smiley. That is, we're just bringing to the court's attention that those statements are in Dr. Clark interviewed Heath Smiley. I was not present.
BG. What was produced in relation to BG?
I guess the same thing that is on the.
All right. SR.
Same thing? Same thing.
Sheriff Higbee.
Same thing, Your Honor.
Tricia Gilbert.
It's gonna be the same thing.
Okay, let's take Tricia Gilbert first. And I understand your investigation, Mr. Kemp. It seems that you didn't do the discovery.
I did not do this. I did not do this list. I have not talked to these witnesses. These witnesses, I'm dealing with other witnesses in other part of it, so I'm not familiar.
Okay, so let me ask you this. Even though the rule prohibits this, the court's going to require two attorneys to respond to this, okay? So I'll let Ms. Todd take this, all right? Is that fair? Did Ms. Todd deal with these witnesses?
Yes, Your Honor.
Okay, thanks.
Your Honor, I wish,
Hold on just a second. As to Tricia Gilbert, what did you turn up?
Your Honor, during a session I had in the DA's office with Ms. Newman and Ryan Berry, I relayed to them that the oral statements that the teachers had made to me during that session. In fact, it was even referenced in their expert report, which we got last night at 6:30 p.m. Our expert report.
We'll get to that.
Yes, sir. Our expert
So
report.
what do you have, other than your word, that you gave these statements to the state?
Well, Your Honor, I didn't record my conversations with the state, but I also told the state during the documents that she's talking about is my direct examination. They asked me if I had any written statements for any witnesses,
That's
and I
not
said,
what the rule says. Did you speak to Tricia Gilbert?
briefly, Your Honor,
What did Tricia Gilbert tell you she's going to testify to?
she's going to testify to what exactly I told the state she was going to testify to.
No, you tell me. I have to make
Yes, Your
I'm
Honor.
making a decision.
She's going to testify that she was one of the last teachers that saw Carly on the day she left the courtroom, and that Carly did
Where's
not
that
seem
at?
angry.
Where's that?
Your Honor, I don't have the witness list in front of me, but I believe it says in the witness list.
Hey, Becca.
Thank you, Your Honor.
Hey, Becca.
Your Honor,
Yes, she is.
in the witness list, it says that she will be regarding her personal knowledge and observations from Carly from the fall of 2023 to March 19th. Carly's behavior and demeanor during the fall of 2023 to March 19th, 2023, based on her personal knowledge of Carly's relationship with her mother, Carly's personality, and her relationship with Keith Smiley and Carly's performance in her classroom. That's exactly what she's going to testify to. And the reason we took it back to the fall is it shows you that she's had Carly in her room for that long. She knows what she's like.
So what did she tell you you intend to elicit?
I just intend to elicit that when Carly left the classroom that day, she did not notice anything that seemed Carly was upset, that Carly was angry, or that Carly had anything but a positive relationship with her mom.
Where's that?
Your Honor, the state sent us the same stuff in their witness list. I had this conversation with the state in person. Didn't feel the need to write it all out again.
Okay. So you don't have any proof other than what you say as to Tricia Gilbert,
I mean,
correct?
I could call Ryan Berry if I needed to, but no, Your Honor.
He's a lawyer, he's not a witness.
Well,
But if you feel the need to, I mean, I'm not gonna stop you. But that's not, how's that relevant? How's what you just said relevant? That she seemed fine when she left school?
Well, Your Honor, I think it goes to Carly's demeanor, Carly's personality, and it will go into what.
State have any objection to a teacher saying that she seemed fine when she left school that day?
I mean, if that's what she wants to elicit from that teacher, and that's her only testimony, that she seemed fine and she had a great relationship with her mother, we would love for them to call her as a witness.
All right, nothing other than that.
That's
Let's
right.
go to the next witness.
Okay.
Next witness. What's
Andrew Clark,
the- Going in reverse order. We'll go into expert section.
Sheer Higbee, same thing.
Okay. Show the court what you turned over in relation to Sheriff.
The same thing that's listed here, that she anticipates that she'll testify regarding her personal observations of Carly from the fall of 2023 to March 19th of 2024, Carly's behavior and demeanor from the fall of 2023 to March 19th of 2024, her relationship with her mother, Carly's overall personality and performance in her classroom.
All right. What's she gonna testify to about the relationship?
Exact same thing to what the other teacher will testify to.
Well, let's articulate it clearly.
Okay, to articulate it clearly, Your Honor, she'll be testifying to that she's known Carly and had Carly in her classroom for the better part of a year during the 2023-2024 school year. She saw Carly on the day of March 19th, that she has known Carly and her mom for quite some time, that Carly is a good student, a good kid, not a troublemaker, not a troubled kid, and that.
That's a lot of character evidence for what particular pertinent trait.
Your Honor, I think it goes to what the
Not
state
sure, Kelly.
introduced as Carly had.
Do what? What'd you say, Jody?
I'm just answering Kelly.
Um,
The mouthful of peanut butter.
Flashman says Court TV has it up for 1:30 today.
Oh,
So I haven't checked it yet.
I'll go and have a look once I've stuffed my mouth.
I said he looked
Can't
like
cook
Mansfield
peanut
too, Becca.
Mhm.
Yes. And Gabby had to explain what that was to me one day. It's nothing bad. Nothing bad. Get your minds out of the gutter. It's just a sandwich.
Mhm.
All right. Sorry, I'm reading chat, not playing this. And yes, you all right. There's bad lawyering both sides.
Mhm.
I'm just amazed at her defense, though. Not thinking they have to write things out or whatever the judge says the rules are. And they're just like, I didn't. Sorry.
Having some troubled child with a history of violence, which is just not true.
State have any objection to the witness testifying that that witness taught her that year, she saw her on that day, that she's a good student, a good kid, not a troublemaker, not a troubled kid?
I think the last part we would object to until after Ms. Gregg testifies, and then she can put on her character witnesses. But as far as her observations of Ms. Gregg on that day, that she was not, didn't seem in distress or abnormal, and that she had a good relationship with her mom, we do not object to that testimony, Your Honor.
All right. Court will allow that testimony only until we get to character witness testimony. Is the next witness on your list?
The next witness on our list is SR, followed by BG. These witnesses are the same witnesses the states are going to call, and we're calling them for the same reasons, Your Honor.
So you didn't turn anything else over? No statements from the juvenile witnesses,
I
right?
haven't even spoken to SR. So
What about BG?
BG spoke to him briefly, but the testimony is the same thing that the state recorded in their interviews.
Right. But they won't be allowed to testify to anything other than what's in the state's interviews. As the court pointed you to the case law, there is no exception to the discovery requirement for the defendant just because they're listed in the discovery by the state. So you can't elicit anything that's not in their report.
Wasn't planning to.
All right. Who's the next witness?
The next witness is James Daniel Floyd.
All right, show me what you turned over in relation to Mr. James Daniel.
Your Honor, the only thing we're anticipating calling Mr. Floyd about is just what he saw on the day of the investigations. I have not had personal conversations with Mr. Floyd. He's just going to confirm the demeanor of Mr. Smiley during the investigations when the police were at the house.
How's that going?
I think it will be relevant to the case in chief when we start talking about the investigation that's going on in cross-examination with the
Well, I
state.
thought you weren't, he's not testifying to the investigation. What's he going to testify to about the investigation?
Your Honor, I feel like talking about this now is somehow going to prejudice Carly with the jury, so I'd rather.
Ms. Todd, you can't hide evidence. You can't go to trial and them not know what the witness is going to say. This is basic 101 law. Mr. Kent, can you cite me a single case, one, where a defendant got to go to trial and not tell them what the other side is going to say?
I definitely agree. We have to turn over our evidence to you.
And we're late. We're real late. Who is James Gilbert? I'm sorry, what was the name of the witness?
James Floyd,
Yeah, who's that?
Carly's maternal uncle.
Excluded. That's excluded. That's excluded as a willful discovery violation. That statement right there, there's nothing that's been turned over of any substance. Excluded. Next witness.
Next witness is Vicki Breland, the maternal grandmother. And it's going to go to the statements she made, not to me, but to the statements she made to the expert witness, Dr. Clark, regarding the family's mental health history.
When was that turned over?
That was turned over on, gosh, the 3rd, Your Honor. We got the state's expert witness report last night at 6 p.m.
You complaining about the state's rebuttal witness to your witness is a bit like a lady standing in the street holding a Christmas hand screaming she's hungry. You were ordered to turn over an expert witness July 28th. You told me it'd be July 22nd. After the discovery deadline passed, we had a new expert witness was hired. So you juxtaposing what they've done with what you've done. Bottom line, what did you turn over to them? Show me what you turned over to them in relation to the grant.
The relation to it would be the statements made to Dr. Clark, Your Honor.
That's in Dr. Clark's report.
And again, Your Honor,
All right.
both the state and the defense had to retain new experts after the discovery deadline was passed.
Well, now the state's expert was retained before.
The
always
state's
forget
expert
to mute.
in being Dr.
Well, the state retained Dr. Gugliano. You instructed the defendant to plead to assert her Fifth Amendment rights during that conversation.
No, we didn't, Your Honor. She
It
did.
says so in Dr. Gugliano's report.
2-1 question.
And then I just got finished reading some of Dr. Pickett's report, and we're going to get to that. But let's stick with the grandmother and what she did. If you want to take shots at them on the expert witness, we'll do that. Show me what you turned over in relation to the grandmother before August 20th.
Your Honor, we didn't have anything for the grandmother before August 20th. That only occurred after the report we received from Dr. Clark, in which Dr. Clark spoke with the grandmother.
You're representing that you had no conversations with this defendant's grandmother.
Not to the nature of anything with the case. We have discussed the trial in general and explained the trial process, Your Honor. We have talked about how Carly's doing, but not anything that would go to testimony that she would put on at trial.
All right. Before we move on from that one, I want to hear a response from the state. Does the state have had the opportunity to speak with her?
Your Honor, no, and I'm looking at Dr. Clark's report. There's no mention of an interview or discussion with Vicki Breland. If they could point me to where in the report it says he relied upon her.
You have a copy of Dr. Clark's report.
I don't have it with me, Your Honor, but he did have a conversation with Ms.
Go get it. We can move on to the next.
I mean,
I can't talk about Dr. Clark's report if you don't have a copy.
would you like me to proceed with Mr. Smiley until we can?
Sure.
Same thing with Heath Smiley. He has given a statement in which was listed in Dr. Clark's report as a 90-minute Zoom conference call. He has done a witness interview, which we received from the state, and several just with the body camera footage of things that happened on March 19th. That's what we're calling him to talk about.
Heath Smiley's testimony will be limited to the matters turned over for August 20th.
Your Honor, I would also cite that Mr. Smiley testified before this court, and we have that transcript on June 4th. The state has that, so we intend to elicit the same testimony at trial that we elicited on June 4th.
You're allowed to do that, so before August 20th.
Perfect.
So before August 20th. All right, is that everybody on the list?
Yes, Your Honor.
All right, if you would return the court's exhibit. And while we move to Mr. Camp, I assume you're handling the expert witnesses. Is that what?
No, this
No,
hearing
Debbie.
is not live. But Becca, you're right in the heart of it. You really, The only thing you missed at the very beginning of this hearing is them arguing over her drug test.
And before that was me and AJ.
It was-
just blah, 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 blah.
Yeah, we were talking. Baker was in chat. We were talking to him.
Oh,
So yeah, no, this hearing is not live, but supposedly in at 1:30 p.m. Eastern time, it's starting.
Mm.
So
that's when they're putting the stream up anyway.
yeah, so we'll see what happens.
What's your,
Yeah, sure.
all right, Ms. Todd, I think your office is across the street. You can go get a copy of Dr. Clark's.
Well, if the state has it, I can reference it right
Yeah,
here.
mine has writing on it, Your Honor. I don't have a clean copy of their
I need a
report.
clean copy of Dr. Clark's report, please. Somebody.
That's not his report.
It's hard for us to proceed without a copy of the report. Yeah, I'll need a few minutes to get a copy.
Yes, I didn't bring a copy of his report with me today.
I can't really address what the grandmother or eat, smile, and sad without seeing Dr. Clark. So let's take a, is there another motion we can handle while somebody gets a copy of them? Either one. There's two lawyers. I don't
Can you
care.
get a copy?
Yeah.
Okay.
But Your Honor, I don't think the court has yet ruled on the state's motions that we did timely file, in which we also asked that the state not be allowed to make speaking objections. We also asked that the state.
He ruled on those at the start.
I did rule on the speaking objections.
Your Honor, our motions were so good, they filed the same ones. As to the
They're
speaking
great.
objection. and-
Thank you, Your
They're
Honor.
granted. I didn't see those. They're granted. Do we have any?
So no sidebars. I'm
Yeah,
excited.
speaking objections.
Get to hear.
He granted that at the start.
Yes. So no sidebars. Yay.
I would assume 12, Gabby. It's Mississippi. I think it's only Florida that has 6, isn't it? Or
But sometimes, like on a DP case, I think Florida has
they have to on a 12, yeah. Yeah,
but
on a
that doesn't
DP.
have to be unanimous. It only has to be, I think, 8 now
Mm.
because they changed the law on the DP thing. I don't agree with that, but they didn't ask me, and I don't live there. So, Becca, that's scary. Hey, sometimes, Elizabeth, if you guys retract something, it doesn't retract in StreamYard, and I don't see it until it's too late. So I apologize if I put up your stuff and you guys have retracted to correct. I try to wait a second, but I can't always see it right away.
And sometimes you go to click on a message and the chat's going so fast, you click on the 3 below it.
That's why I'm like, sometimes I'll click right off. It's not that I don't want to show it. I'm trying to get somewhere else, but you guys zoom it. So not complaining at all. What? Wait.
That was me, Becca. It was me.
That's not what objections means. It just means they can't say objection, hearsay, this witness says this or that. I thought no speaking objections meant they can't say what it is. I don't know. We'll see.
No, speaking objection is where they can get up and say objection, hearsay, and then explain it. Whereas a non-speaking objection is you just objection, hearsay, and then sidebar, isn't it?
Yeah,
They
sidebars
still can
still
do
be
sidebars
allowed.
for
Yes,
sensitive
but it
stuff.
won't
Yeah.
have to be like what we just
Yeah.
watched, where everything was, can we approach? Can we approach?
Yeah.
I pinned that up there, Becca. So thank you.
Any other motions we can hear before somebody can get me a copy of Dr. Clark?
We can do we have our cursory motion to move it down to the youth court. that we
No,
filed sometime.
They allowed speaking
Okay, I can hear
objections.
that. Can we work on getting Dr. Clark's report? Someone.
Yeah.
Your Honor, may I address briefly the substance and just cite the court to the attachment that I filed, which shows that we were missing each statement, the teacher's names and substance of their testimony, Dr. Webb's report, and potentially a journal of Ashley. That was on August the 20th when we signed for it. So they knew at that time that we did not have the teacher's names or the substance of their testimony.
Is there an alleged journal of Ashley Smile?
We do not have a journal of Ashley Smile.
Does anybody have an alleged journal of Ashley Smile?
I don't think my understanding, we don't have it. We
Ashley
do
is
not.
mum,
Where
isn't
did
it?
that come from in Dr. Pickett's report? I've been able to read about 17 pages of Dr. Pickett's report. And he references the journal of Ashley Smile. Who gave him? I don't think Dr. Pickett just made up the journal, did he?
We didn't provide Dr. Pickett with anything. So if he's, that would have been something that the state gave him. That's not.
All right, let's take 15-minute recess. Y'all get to go get Dr. Clark. 15-minute recess.
Yes. So the judge is allowing speaking objections. So there shouldn't be as many sidebars.
Sidebar.
Also, I'm surprised the stepdad would be testifying for the defense.
Mm.
All right, we're going to move in particular to the state's motion to exclude, for lack of a better term, the expert witnesses. All right, as I appreciate it, the state wishes to exclude the report of Dr. Gerald O'Brien. Is that correct?
That's correct, Your Honor.
Defense doesn't have a report for Dr. Gerald O'Brien,
Don't
correct?
have
That is correct.
All right, so you confess that, correct?
There has never been a report.
Yeah, check my link.
State wants to exclude the report of Dr. Mark Webb. Is that correct?
That's correct, Your Honor.
There's no report of Dr. Webb. Is that correct?
That is
No.
correct.
So you confess as to Dr. Webb.
Yes, Your Honor.
Let's move to, is it Andrew Clark?
Yes, Your Honor. Yes, sir.
All right, does anybody have a copy of Dr. Clark's report for me?
Yes, Your Honor.
Let's mark that, if you would. Ms. Newman, take a look at it. If y'all agree that's the report you received, let's mark it D1. D2, excuse me.
Sorry, Judge. Check your page, yeah. All right, Judge, right on.
All right, this is the state's motion.
She's got the personality of an egg.
Was there anybody else that we did not touch on?
No, sir.
So Dr. Clark, correct?
That's correct.
May I proceed? Your Honor, the motion was actually filed on August the 30th, 2024, the deadline for motions for filing in this case. We at the time did not at all have a copy of the report from Dr. Clark. I think we were in possession of a CD, but that was it. We received on September the 3rd at 7:09 p.m., we received a forensic evaluation report from Dr. Clark. We still now maintain that his report should be excluded, not because we didn't have it, but because it does not apply the proper standard for insanity. It does not comply with McNaughton. And we believe that it's more prejudicial than probative and would confuse the jury as to issues, which leads to why we do not think that they should be entitled to mention an insanity defense or insanity. His opinion, again, does not cover the McNaughton standard. It appears to cover a diminished capacity standard, which the state of Mississippi does not recognize. In addition,
Where is his, I was just handed the report called, where in the report is his opinion?
he has a summary opinion, Your Honor, on page 24, the very last paragraph of that page.
I apologize.
That's right, Your Honor. We believe that opinion is in reference to a diminished capacity standard upon which the state of Mississippi does not recognize. In our motion, we asked for a Daubert hearing. I do not see Mr. Clark in appearance. I don't know what he looks like, but I asked defense counsel if they intended to have him here before trial, and I was told he was not going to be here. So again, all we have to rely upon is his report, where in fact he does not cite to the proper standard from McNaughton. There are plenty of cases within this state that have excluded similar testimony when it is confusing to the jury. And again, this might be proper for something at sentencing, if I don't want to put the cart before the horse, but if the jury were to find her guilty when the state then requests for a sentencing of life, this might be appropriate for that, but it is not appropriate for comment in front of the jury at any time prior to that. And again, our motion essentially talked about Daubert and the standard. Again, he should be excluded under 702 because his opinion does not reference the proper legal standard in the state of Mississippi.
Anything further?
No, sir, Your Honor.
Response.
Yeah, if they're arguing that they wanted a Daubert motion, in their motion that they filed, what they're saying is that they did not have a report. And so based upon not having a report, that there weren't any foundations or anything laid at that point. The report was given to them on September 3rd. There has not been an amended issue on this. We have not been put on notice or anything that his report did not suffice them to say that he's arguing McNaughton. He is arguing McNaughton. That is the whole thing that we have talked about. It is not diminished capacity. It is McNaughton. It's what his argument has always been, and that's what we intend to put on if he's our expert.
All right, let me ask this, and you're saying you haven't been put on notice about their argument, but their defense, how can they file a motion on something they don't have?
Your Honor, I agree. We provided that as soon as we got it. We turned around the same day that we got the report. We gave it to them. In fact, I think Dr. Clark did his evaluation on Thursday, and then within a few days had his report, and we provided it to them. That was done as quickly as we possibly could. And I just sort of want to point out, both sides had to get different doctors. Dr. Guglio was the initial person that was supposed to do both the McNaughton and the competency. And then she was not able to do the McNaughton, and so you had to get a separate doctor that then he went and did the McNaughton part for the state. So both sides have had the same issue.
Hang on, because I recall Dr. Gugliano basically stopped the interview once she asked the defendant whether or not she had ever refused prescription medication. And she basically said, I'm going to plead the fifth to that. She said, I can't testify as to prescription issues. I'm not a psychiatrist. I mean, had the state been provided evidence, not what somebody says. We're lawyers, we're not witnesses, right? They could go in a different direction. Bummer, they're both late. Okay, they're both late. Do you want me to exclude them both?
Well, I think both of them have to come in, Your Honor. And part of this is not again, most of the case law was talking about if it's obviously, I think the court says this is not intentional on either side. This is just dealing with psychological issues and we had to reevaluate, right at the end. Both of us had to get new experts. Both of us were jumping through hoops to make that happen. We provided a report. They've provided a report. There's not surprise. There's the trials next Monday is when that's set for. That's the main issue is if this stuff is coming in, if we're giving you, or either side's giving reports right at the last minute, that's what the court sort of is addressing as far as excluding all this information and stuff. And that's not what the intent is. I
keep asking myself that same question, Sharon.
Down here, get him to do an evaluation and get the report done. And we think the report suffices, and it is definitely not diminished capacity is what we're arguing, Your Honor.
Okay, well, let's nail this down. Are you arguing automatism by way of involuntary intoxication? Or are you arguing no?
We're arguing that not.
So you're not arguing automatism by way of involuntary intoxication.
We're not saying voluntary intoxication.
Involuntary.
We're not saying involuntary intoxication. We're saying that there in the report there's a whole bunch of different issues that are going on, and that's what impacts her ability to make the determination between right and wrong. And that's in a summary at the very end.
What did she?
All right. If this hasn't been turned over, if Dr. Clark is available by Zoom to speak to him smiling, he should be available by Zoom to speak to the state investigation, shouldn't he?
I don't have a problem with that at all, Your Honor. In fact, I was surprised that didn't happen with Dr. Pickett.
Well, again, I've already made my analogy about you complaining about Dr. Pickett.
They never
Dr.
do.
Pickett turned over the report in 7 days procedurally. So you're not on good footing here. How about that? All right, anything further?
No, Your Honor.
All right, reply by the state.
For clarification, we have permission to talk to Dr. Clark
Let's
about,
not get to it. That's just proposed.
I'm sorry.
All right, by way of.
I haven't gone anywhere. I'm still here.
Take objection to,
Can you not see me?
speak to Dr. Clark, even if it's by Zoom or whatever. in order
Jazz
to
hands.
alleviate late discovery.
Yeah, Your Honor. So in our initial motion, we requested a Daubert hearing and further order compelling them to provide the materials that they provided to the expert. So again, we don't have any 90-minute. He says that he relied upon a 90-minute Zoom interview with Heath Smiley, as well as a 4-hour interview with Gregg. I think we would certainly love to talk to him about what disclosures were made during that. But I think this court has ruled already that Heath Smiley will be limited to his testimony prior to August the 20th and in court. But I still think that there's some things we need to ask. But the state still would like a proper Daubert. We do not believe that his opinions meet the standard, and would request that we have a Daubert hearing prior to voir dire, Judge. We don't think that that's
Daubert
fair.
hearing prior to voir dire.
Voir dire on an issue, not knowing whether the insanity defense would even be argued.
Okay, so let's take this second step. The state's objection to the court granting you time at a Zoom meeting. However, and you discussed this with Dr. Clark. What's the objection to that?
No objection, Your Honor. If he's willing to talk to us candidly.
Is there anything else in Dr. Clark's report that you've not received?
Court's indulgent. I'm not sure. He may can clear this up. Pages of Carly's diary. It's been my understanding that there's some other diary out there that we don't have. And of course, if the defendant doesn't intend to introduce it into evidence, we might not be entitled to that. However, if he relied upon that, we certainly would want to know which diary he's talking about, the ones that were produced by the state in evidence or the ones that are in the custody of the defendant.
I'm completely lost here. First of all, how does anybody intend to get a diary? You know, that's Orange Book law, that a diary is hearsay evidence. That's basic first day, second year of law school evidence class. How do you propose that you won't get a diary?
Of the defendant?
Dang.
Her own statements?
Okay. Excuse me.
Yes, sir.
All right, so all you have is a diary of the defendant, Carly Gregg, correct?
So, Your Honor, we produce some of Carly's diaries in evidence. Law enforcement sees some. It's our understanding that the defense is also in possession of some additional diaries that they took out of the home after law enforcement left. And
Does
granted,
the defense have some diaries they intend to, that they gave to Dr. Clark?
No, Your Honor, everything that was given to Dr. Clark was from the state's discovery.
Okay, so it is only the defendant, Carly Gregg's diaries, correct?
if that's what they're saying, the pages that were produced in discovery, if that's all he relied upon, that's fine. We just wanted to make sure that we know what he's relying upon. Yes, sir.
So there's no other diaries by the state?
No.
By the defense?
No.
All right, so there's no diary of Ashley Smiley by the state?
The state did not produce a diary of Ashley Smiley. The defense emailed Dr. Pickett on August the 22nd a typed what they had labeled journal of Ashley Smiley, and that's what Dr. Pickett was relying upon in his report.
Does the defense have some purported diary of Ashley Smiley?
Your Honor, it's a visitation log that I labeled journal, but it was turned over the day I received it to both Dr. Pickett and Ms. Newman. It was CC'd on the email. So the day I got it in my possession to send to Dr. Pickett, it was sent to the state.
And Your Honor, I apologize for talking over. We are in receipt of that. We're not alleging that we're not.
Whose journal is this?
Allegedly, Ashley Smiley's.
Where did you receive Ashley Smiley's journal from?
Your Honor, it was in a packet that the family brought to me that had divorce proceedings and those type documents in there. It's a visitation log that she kept that had various issues written in there. So the day I received it and found it, I gave it to the state and Dr. Pickett, the state's expert.
So we have an expert relying on unauthentic, hearsay of hearsay.
I can't get mine to come up. I'm talking about the membership, not. Yeah, that was bad. Sorry. Yeah.
Yeah, after just
Asked
reading
that.
a couple chats back and then you
Yeah, I asked for that. Bad interruption time.
Well, thank you, Gabby. Why didn't it change your 6 to a 7?
Yeah. I've been waiting for my next one to come up for ages and I can't seem to.
Really?
Yeah.
It should be down there. It should tell you when it's down there.
Don't you have to go into like your chat and then into the.
No. I mean, you have to be on my, yes, you'd have to be on
Yeah.
my channel. And then where the $sign is,
Yeah.
hit that and it will tell you if you have one.
Yeah. Yeah.
But it should tell
I've been
you.
doing that every time we've been streaming and
Oh, you did one last week.
ages ago.
No, last week for 2 months or 1 month. You did one here recently. Oh, really?
Objections
Yeah,
to
I
that,
forget
yeah.
about that. All right. The cast of characters are mom, deceased, stepdad, hit in the shoulder, survived. What's her face there? Carly Gregg. I was trying to think of the woman on the Beetlejuice character. Couldn't. Sorry. That's the main cast of characters. Bad lawyer number 1, that looks like Mansfield. Bad lawyer number 2 is porcelain skin, beautiful hair down here at the defense table. Ashley was her mother. So Ashley Smiley was her mother. Heath Smiley was her stepfather. And she unalived her mother, used the phone to text the stepfather to come home and was going to ambush him as well. Failed at that. They haven't said the name of the friend because I would assume she's a minor. He or she is a minor that she texted to come over because she asked her if she'd ever seen an unalived body. So they've not said any of the minors' names. They've just given their initials. And that's the main cast of characters here. Judge is awesome. Judge Dewey, can't think of his last name. Arthur is amazing. And sorry, Flashman, what did you say? I was a member, mine times out because I annoyed y'all. What? I don't know what you're talking about, Flashman. I believe the friend came over. Yes, because she acted like it was an emergency to get the person over there. I keep saying her because I just assumed it was a girl. That is a complete assumption. Because once Carly got the friend there, that's when she asked the friend if she had ever seen a deceased body. The stepdad did not run off. She hit him with one round in the shoulder, and he was then able to wrestle the weapon away from her, and she ran off. She jumped the fence in the backyard. She didn't go very far. It didn't take them long to apprehend her once the police were called. They had a helicopter up, but she was arrested pretty shortly thereafter. And I think that catches you up pretty much. I think. Flash fan, I want to know what you're talking about. Because now I'm confused. Oh. I was going to say, I didn't think that could happen. She hopped the fence when her stepdad wrestled the weapon away from her. That's where I don't know where the friend went at that point. Once they never mentioned the friend again. So stepdad gets home. She tries to ambush him. He's able to wrestle away from her. Then Carly jumps the fence and tries to take off, but didn't try very hard. About as hard as she looks like she's trying to sit there in that chair. But I don't know what happened to the friend. I never did see again what happened to the friend. Do you know, Jody? Did they say anything else about the friend?
Just looking it up now. Just having a read. There's an article I can share with you if you want. Do you want me to share page? I haven't read all of it, but we can have a go through once you've finished this hearing, if you like.
Sure. They're doing that today. Becca, we're just waiting on it. That's what's supposed to start at 1:30. I don't know what that means. You do.
I can't see chat or anything at the minute. I'm in another page, sorry.
And I don't understand if all the family members are testifying for both sides. That's crazy. And I'm shocked that her stepdad is testifying for the defense. But it's going to be
Alright.
very limited to what he has to say because they didn't file anything about it.
This says that there was a video recording that was captured on home security cameras. The footage from the cameras show the minutes leading up to the unaliving. The suspect and her mother return home, and after some time, the suspect is seen going into her mother's bedroom. Then you hear a bang, a scream, followed by 2 more bangs. One video shows the suspect returning to the kitchen where she is seen texting from a phone. Adding to that, later investigation found the teen was allegedly messaging her stepfather when he would be home. In between the time, she allegedly unalived the mother and her stepfather. The suspect is seen singing to her dog. At one point, the suspect asks a friend to come over, saying it's an emergency. After the friend was driven over to the residence by her father, the suspect asked the friend if she had ever seen an unalived body before. When the friend said no, the suspect proceeded to show her deceased mother, further alleging that the suspect also showed her friend the weapon.
And that's what I read too. So I don't know then if the friend ran away.
I think she would have run straight back into the car and...
You would think.
Mm.
But you also would think that they would have then knew about it before the stepdad was able to get home. So I'm not sure, but...
No forthcoming information.
No. I think it's going to be hard because they're minors. It's going to be
and there's
difficult.
limited information out there that we can access because it's behind a paywall. So
yeah,
but I'll keep looking.
I'll keep playing.
Is not able to be authenticated. Double hearsay. They can't be authenticated. Anything else?
Your Honor, again, we'd ask that we be allowed to have a on-the-record Daubert hearing of Dr. Clark prior to voir dire in this case.
Mr. Kemp, is there an objection to the state having a Daubert hearing before trial?
Your Honor, if they, I guess after talking with Dr. Clark, if they still want to do that, I don't have any objection to doing a Daubert hearing if they need it. Hopefully it can be resolved by them talking with Dr. Clark to clarify that he is doing McNaughton. If he's doing McNaughton, I think that answers their question for him. It's not diminished capacity.
All right. Anything further from the state?
Yes, sir, Your Honor, that Dr. Clark not be able to amend his findings subsequent to our conversation.
All right. Court is looking at Rule 17.2, Rule 17.3, and Rule 17.4. There's no argument that the defendant requested rule evidence that requested discovery under Rule 17. The fact witnesses in this case that were proposed are wholly different than the expert in these courts. I believe I understand what happened with Dr. Webb. The defense can't help but I don't think Dr. Wells ever give you what you need or what you want. You're putting screens on a position. So you obtained an expert who got it pretty quick. However, the state's right. There are things where he wants, these experts are relying on double hearsay that can't be authenticated. Now, experts can rely on some hearsay, but you have to be able to prove some reliability. I have to be frank, a journal that miraculously appears at the 11th hour is suspect. This is what the court's going to do. Today is September 10th. If the defense intends for Dr. Clark to testify, you need to arrange sometime tomorrow that a Zoom conference can be held so the state can question Dr. Clark. We will meet back here Friday morning, the 13th, and we will have a hearing. If the state wishes to exclude part of it, file a written motion. If you still believe it is diminished capacity, we'll look at it. This case follows the state follows 250-year-old law in regards to insanity. I believe it is a very wise decision that we continue to follow that 250-year law. It has stood the test of time. This court is not going to be a trailblazer. However, there will most likely be, I'm not putting the cart before the horse, but if the jury does not acquit her, there will be a sentencing phase. I expect diminished capacity can be used in the sentencing phase. So while diminished capacity may not be necessarily admissible during the guilt phase, it would be admissible during the sentencing phase. Can Dr. Clark be here for a Daubert hearing if necessary on the 13th? To the defense.
If needed, Your Honor, we can get him here.
Okay. All right. This is what the court is looking at. The court found there was a discovery violation. However, as Dr. Clark, the court is not inclined to exclude the witness at this time. The court is looking at 17.4, the effective failure to comply. A, granting a continuance or assessing costs against the appropriate attorney or party. I'll just be quite frank, we can't promote for 20 years. I don't intend to assess you a cost at this point in time. But I've never seen this from you. If I have to grant a continuance from the 16th, I can continue it to the 23rd. But I'll address that on this Friday. But the court intends for the case to be tried this term. Second thing, B, limiting further discovery of the party failing to comply. This is it. No amendment of Dr. Clark's rule. We're going to ride the horse we brought. Finding the attorney failing to comply in contempt, or excluding the testimony of appropriate witnesses. And we get a defense.
Bye, Elizabeth. Thank you for joining us. Come back when you get your phone charged.
Bye, sweetie.
Jody, will you look and see if you can find, was there the hearing from Friday? While we were trapped in that engaging Lori Shaver trial?
Do you want me to find the hearing from Friday?
If you can.
I have saved a few on my.
Give us, then
Let's
we can
have a look. See.
Okay, I'm gonna finish
I've
this up. We're
got
almost
hidden
done with it.
playlists.
Yeah, I feel you.
Friday's hearing. Let me look.
Yes, Kelly, it's Mississippi. And I'm not sure, is Mississippi on Central Time or Eastern Time? But I keep forgetting to look. All right, I'm gonna hit play because this one's almost finished.
Mm-hmm.
Ah, dang.
All right, the court went over arrest warrant. Court looked at it. For example, Vicky Breeden is a witness closely identified with the defendant. The late disclosure, that's what this court has a problem with, a witness closely identified with the defendant. What is provided is not the substance of her testimony. Same with James Daniel Ford. What the rules are concerned with is not a listing of witnesses. Nowhere in the rules does it say provide a list of witnesses. It says provide the name, the address, the substance of the testimony, written, recorded, or oral otherwise. When I look at Vicky Breeden and James Ford, Shara Higbee, Tricia Gilbert, those are witnesses closely identified with the defense. For those reasons, the court stands by its prior ruling. He's smiling. Mr. Smiley has made it very clear that he wishes to stand with the defendant as a witness, closely identified with the defense. He'll be limited to everything he's testified to before or the statements previously provided by the state. As to Dr. Andrew Clark, the court is going to delay its decision, allow the state time to interview the witness, prepare any objections that need to be made, or conduct a discovery. The court believes that's a fair way to allow the defendant to put forward her evidence, whether it be in sentencing or in the guilt phase. But that's going to be the court's ruling right now. We will reconvene here this Friday, the 6th, at 9 a.m. I expect at that time for the state to announce either you're prepared to proceed or we're not prepared to proceed. If you're not prepared to proceed, why are you not prepared to proceed? And what in particular will you need to proceed? All right. The second thing the court will be looking at is a Daubert style hearing, if required. We'll be looking at, is this diminished capacity evidence, or is this McNaughton evidence? And I'll hear arguments as to why it's diminished capacity or why it's McNaughton at the time. All right, is there anything I've made clear for the state?
Ryan, just to be clear, the Friday the 13th, right? This Friday.
Yeah, I'm sorry. I said Friday the 6th.
Yes.
Friday the 13th.
Thank
Excuse me. Worst day I can imagine having here. Friday the 13th. All right. Is there anything I've been clear on, Mr. King?
No, Your Honor.
All right. Were there any other motions by the state?
First indulgence. Oh, no, in general. No, sorry, Your Honor.
All right. By the defense. Any further motions? Did you want to argue the motion to transfer to youth court now?
Your Honor, I would, if I'll go to the podium. We have filed our motion. We think that it would be in Carly's best interest, it'd be in the best interest of justice. We filed the motion some time ago. We know we have a trial date coming up, but we'd ask the court if we could transfer the case to youth court in the interest of justice.
Response by the state other than your written response.
Our written response, Your Honor, and just for judicial notice, the youth court prosecutor, Corey Garber, is still present in the courtroom. Just would like to, if the court would like to hear from him on whether or not the youth court would be interested in entertaining his grandmother.
It's your motion. Do you want to call the witness or not?
It's not my motion, Your Honor, it's the business motion.
That's your response.
Oh, sure.
All right, if you want to call them, I might call them.
Sure, Your Honor. The state calls Corey Gerber.
Mr. Gerber, do you understand that you were still on the road? Still sworn to testify?
Yes, Your Honor.
Mr. Gerber, I believe back in June of this year, my office contacted the youth court and sent y'all a copy of the motion and possibly our response in opposition to the defendant's motion to transfer to youth court. As a representative of the youth court, do you have an opinion on whether or not the youth court is the appropriate venue or jurisdiction for Carly Gregg, who's been charged with murder, attempted murder, and tampering with physical evidence?
Under the rules, under the statute, youth court should only be handling cases where there's a reasonable prospect of rehabilitation. I have not followed this case, but I'm unaware of any reasonable prospect of rehabilitation in the juvenile justice system for someone who has committed the crimes which you just listed.
No further questions, Your Honor.
Cross-examination.
Corey, if the individual, I guess, had some mental issues and things like that, there are, I guess, different avenues that the youth court could follow, correct?
I'm going to need you to clarify your question.
You have, I guess you have counselors and you have people that could come in and see her, correct?
We do have counselors. So Region 8 has a counselor on staff at the Juvenile Detention Center who visits with children who are detained there, yes.
And right now where Carly's at is she's in solitary confinement because she has no, she's in the adult jail. She doesn't get to, she has to be housed separately. So for this entire time, she is in solitary confinement. She didn't get to interact with any of.
Hello, Baker. You scared the crap out of me.
He's got an hour to kill, isn't he?
Scared the absolute crap out of me. Thank you. I looked. I was like, wait, where did all those people come from?
I wasn't paying attention. I was researching. Sorry.
I was typing something and I looked. I was like, holy crap, what happened?
Welcome, welcome.
Yes, welcome. Thank you, Baker. Baker, did you see Court TV has a set to start at 1:30 p.m.? I don't know if that will be the actual
so does
start.
WMB3 or whatever it is. But yeah, they could sit there and stare at the ceiling for 45 minutes.
True.
Before proceedings start. So
You're making muffins.
We're just watching the tail end of the last hearing that was done on Tuesday. The what is it?
Oh, the hearing.
Yeah, I'm brain dead. It's 2:30 in the morning here.
Yeah. Not here, but I was reading the chat. This was the hearing. Let's see. They tried to get her to move to youth court. That's what they're talking about right now. They argued the defense sucks, and they didn't turn a bunch of stuff in on time that the state filed motions for. And I don't, other than to say that they did not even respond. He just went through, the judge went through at the beginning of this saying the state filed a motion in limine for this, state filed a motion in limine for that. No response, no response, no response. Granted. They've argued about her drug testing, which was nothing. And the judges basically told the defense and sometimes the state, you guys haven't done your jobs. Susan, she is accused of unaliving her mother and trying to unalive her stepfather. So she was 14 at the time. She has turned 15 now. And yeah.
I've got a whole spiel on it if you want it. That's what I've been doing behind the scenes.
No, trying to.
There you go. I've just shared it with you if you want to use it. I've just sort of copied and pasted from. Welcome.
Yeah.
Except we'll call you, what J name has he called you today? Absolutely.
I just know that he scared the crap out of me. That's all I know.
So if you finished, Baker, you're going to start back tomorrow, or
He's
you don't
set
think
for
the stream will
2.
start up tonight?
It is very, very sad. There may be some mental health issues there, but she was found competent to stand trial last month. She was switched from, I don't know from what medication, to Lexapro so a week prior to this happening. I don't know if that has, I don't know, because those medications, especially with young kids, have bad effects.
Add Mary Jane to it.
And then there's that. But I kind of agree with Adair on that one.
Well, that's
Make you go crazy like that.
We were talking about that the other day. The stuff that you used to grow in your backyard from a seed ain't what you get on the streets now.
True.
It's all genetically modified. They know the exact, like the THC levels are through the roof. They're like 32%. You can get, they're just so synthetically grown now. It's completely different than what you used to get. So, and I've actually personally had a friend that was a neighbour, exactly my age, great guy, actually had a bit of the hots for him, but we'll go, that's another story. He went out one night and had one J. He had a predisposition for schizophrenia, ruined his life.
Really?
That triggered his schizophrenia, and he became totally dependent. He could not live independently, and he was only 19.
Yikes.
True story. So, and that was just from one.
That's crazy.
Yep.
I mean, obviously, like we were talking earlier, I don't know. When you
don't know if you've got the predisposition.
They look at 2 different time periods.
The genetic predisposition for anything like that until it's too late. It ain't worth it, peeps.
No. And
drugs are bad, okay?
Jedi Jess are. I don't know, because when the competency hearing came up, the state just said they stipulated to it and they agreed she was good to go. So there really wasn't any discussion about what happened. And I think the doctor, didn't they call that one doctor to the stand? But maybe the doctor they were arguing about earlier. I watched that so long ago now I don't remember. Because I've watched too many other things in between. Jedi Jess are. I'm going to stop talking.
Yes, Adair, she was offered 40 years and she turned it down. But if you want that, if you can see my share screen there, AJ, it's a whole list of from the start to finish, family names.
Well, Baker, I'm Baker. I'm going to have to put a note on my notepad. Just I'm going to have a yellow Post-it note.
Jedi Jess rocks.
I have one right here. And it's yellow.
I got up to 13, but then I stopped counting because I was
stopped
busy.
counting because I missed them. That her name is Jasmine. I'll just have to have that on my computer.
No, it's not. He just calls her a J name every time. A different one.
Can I just call her J? Can I just, never mind.
You called her Jody last time she was on.
Really wouldn't be any need to be, if she was medicated to help her in her defense, and she'll be competent. It's pretty low standard. Somebody asked today if we thought that she was medicated.
Mm.
And
Problem is, it takes a while to get that, as I said, that therapeutic level, and you don't know what dosage of the drug at over what time period will get that therapeutic level to work for you. So it's
well,
it's not.
great. It takes a long time to even figure out if you're on the right one. So
Yep,
it's
exactly.
a lot of trial and error.
Mm-hmm.
And my thing with her though is she has been so unattached, detached to
Yeah.
this situation that's why I was like brought up kind of like wasn't saying it in a derogatory way. Is she a psychopath that's in the making? Because they don't have feelings. They don't like they
Mm.
can do that what she
The
did.
empathy is
And
missing,
there's no empathy there at all.
or
And
is it medication,
I don't know.
or both?
So, does she do something early that thank goodness she didn't have time to do something worse later? If I'm trying to say that nicely.
Mm.
Um,
Yeah.
well, we've had Catholic schoolgirl. Now we have Beetlejuice. So the yellow thing, the jail thing was
The bangs
it
got to go though. Like,
bangs. Her hair needs cut
can't see her eyes.
unless they're straight on at you.
Mm-hmm.
Psych meds are also notoriously do wonky
Mm-hmm.
things. Yes. Yep. And that's what I was saying earlier. Like kids that were put on Prozac or things like that would go do horrible things because of the effects of the medication that was to
Mm-hmm.
help them, but they were too young to be on it. Um, yeah, it's all just, I think her attorneys are horrible. I don't think they have done their jobs of trying to get her evaluated correctly. And if she ends up in the adult prison system at 15 years old, she'll never be evaluated. She'll never get help. She won't survive it. I mean, she's so tiny anyway. I don't know. That's my opinion, though. So,
Mm.
all right. So I don't know if I think you guys watched this, but we'll finish it up and then I'll put your what you got up here.
Oh, well, no, basically, as I was going through, I was searching for what you were asking for, a hearing on Friday. This is the last one. This is the latest one. Anything that was screened or streamed since then is this trial, is this
Okay.
hearing. It's the
Okay.
same one. I've gone through Court TV, WLBT3 and Law and Crime. There is no hearings
So I wonder what happened because I
after
saw
this
that
one.
Flash fan said there wasn't a hearing Friday, but I couldn't get your attention.
I think the ones that they streamed on Friday is this one that I repeated it because
Oh,
I actually went on and played it, like bits of it, and it's the same hearing. So
even
unless
though he said they were having a hearing on Friday the 13th.
I can't find anything on, as I said, Law Crime, Court TV, I even went on to Vinny or WLBT3.
Susan, most people that walk into the doctor's office now, they want a pill to cure it. They don't want
Yeah.
to have to fix anything themselves.
Or they treat a symptom instead of the cause.
Yes.
Mm.
I did not try waving my arms because I knew she would just wave me off.
Mm.
That's you, Jody.
Mm-hmm. Mm-hmm.
Do you know what I'm talking about, Jody? When you
Yeah.
just waved me off?
Mm-hmm. It's all
Becca,
right.
remember when Jody just waved us
Yeah.
off?
Mm-hmm. I didn't wave you off. I was like,
You waved us off. We have video to prove it.
Mm-hmm.
Um,
I'm about to put another one up.
I don't know that
Not to one.
that's true, Becca. She
3 in the face.
unalives her mom in the
Mm.
face, calls her friend as an emergency, asks her if she's ever, and is excited about it, dancing around in the kitchen, singing to the dogs, tells her friend she's got 2 in the, it's in my description.
Yeah,
There's a
she
quote,
yeah,
2 in the something and 1 in the chest for stepdad,
waiting for
ambushes
Heath.
him.
2 for the head, 1 for the chest, waiting for Heath.
So ambushes him. I don't know. That's pretty bad for 14. I guess they did whatever was supposed to happen in court. Probably. They didn't want us to see it. If the state didn't have objections, there would be nothing to have a hearing. See? Becca remembers you waving us off like we were flies. She's loony, maybe just not legally loony. Well,
Who are we talking about?
I was gonna say, might need
That's
to be a little bit
debatable.
more specific. I was going to a doctor that give me too many. I had them checked and found the majority should not have been taken together. Yeah, well, you have that too. It's hard to find one that's in the middle sometimes. You've got the ones that just here, take this, get in, get out of my office. You have some that you're like, hey, I'm having an issue. And they're like, okay, well, go fix it. And they don't do anything when you do need something. And then it's hard to find those in the middle. And it's hard to find a good doctor sometimes too. It wasn't like the teen who sent the babysitter home.
Don't remember that one.
Which one is that one, Becca? Speaking of her, Becca,
Mm.
I don't know what you're talking about. Ew.
She's
Did you?
She's been YouTube correct.
I see the difference.
Mm.
I do. However, I do and I don't because she's got something wrong with her. I'm sorry. She just does. Just her sitting there. She's just detached. But did you see there was a hearing? You know the Sebastian Rogers case down there in Tennessee, the boy, like the autistic boy that just
It's
flat out
missing.
like
Yeah.
disappeared.
Mm.
His parents have apparently like some protective order against some YouTuber, and there was a hearing on it.
Bullhorn Betty.
Yes.
She cray. Oh, sorry.
Okay. Well, don't bring her here. But
Mm.
that was crazy. I kind of was listening to a little bit of it this morning, but I
heard about it, but I'd watched, I think, about 20 seconds of one of her lives and had to turn it off. I just couldn't watch it anymore.
So I was
Mm.
like, wow.
Mm.
I just wanted to make sure there wasn't somebody normal that was going to get up, like we would get in trouble.
No, I would not categorize it as that. You're gonna have to see that for yourself, though.
She was stalking them and claiming they disappeared him. Ooh,
Mm.
that's a pretty big allegation to make.
Yeah.
Yikes.
Yeah. She had their house on some Google app and was like going right through, and then she brought up pictures of inside the house from the previous owners as well, and just yeah.
Wow.
Mm-hmm.
I do not know that name. is in your state.
Oh, you mean yeah. She was the model, isn't it?
Well, I was thinking of John Benet Ramsey,
Yeah.
but
Oh, that's who I was thinking too.
that's not the same.
Oh,
And she wasn't sabulated.
oh,
So,
I'm confused.
me too.
Take me much.
Me either. Yeah, that's insane. I guess if you're going to do that, then
Mm. It's something you're just going to have to go and have a look for yourself.
no, I think I want to stay out of that
Yeah.
Sebastian Rogers situation, but sent his babysitter home. I feel like we're playing a trivia game and she's trying to just give us
Let me
hints.
Google.
Ella Bennett. Yeah, no, wow, I agree. That would be
Mm.
Abilene, Texas. All right.
There's
Really?
another trial on that starts on Wednesday, and it's about Erin Melody. Apparently, this is a Coney Island beach case. I don't know if they'd be live streaming it in the King's Supreme Court, but apparently she unalived her 3 young children by drowning. Young,
Another
like
one.
the youngest, I think, was just 1. I think.
Why do the moms do that?
Yeah.
Yes, we've been waiting for that one, Flash Fan. There's a lot
Maddie Soto, yeah.
going on there.
There's Stephen Stearns.
Ooh-wee.
Yeah. I still think that the mother's really more than she letting on.
Yes.
Just me though.
Maybe, allegedly.
Yeah. All right, let me Google this while you finish that. Mr. Google, sing me a song.
Next thing you know, what she's going to say, I only want to see Mr. Google from here up.
That was gold. Come on. That was gold. You don't have to pay that one. That was straight off the cuff.
Oh, I've told everyone about it. Like, they don't even know you.
I got that off Baker. So blame him.
Here up. All right. I'm going to play the end of this so we can get it done. And then we can look at something else for 30 minutes.
Oh, dear.
She told her grandma about you, Jody. It's the ever fascinating and intriguing trial of Gloria Shaver that we had last week that we just all were just hanging on to for dear life. When the FBI agent testified, Jody said she would just like to see him from here up.
And then he had pistol grip ears. He did.
And then you can imagine how off the rails the chat went. So
Yep. This Paris Lee Bennett is a UK case.
oh, that would be why we probably didn't hear about it. Oh, Lord.
Yes. You need to do a really like a tab for really, really, really weird stuff on Discord, like out there stuff. There's a lot.
Oh, Becca says it's not a UK case. Where is it, Becca? Is it in Florida where all of it is? Oh, you said
sorry,
Abilene,
sorry.
Texas.
It's a UK
Sorry.
News was looking at it. Sorry.
Sorry.
But it was in 2020.
That's before my YouTube time.
Mm-hmm. Oh. Oh, he's creepy looking.
He likes to do those interviews, doesn't he? Sometimes they're hard to watch. All right, I'm really pushing play now.
Ever other people her age or anything like that. If she was at the youth court and at the youth detention center, would she be able to interact with people her own age?
And she would be isolated. It's like sound separation. She is considered to be an adult. It's fairly clear that under the federal rule that anybody charged as an adult cannot be held and detained the same as a juvenile. When she was detained at the juvenile detention center, she was kept separate from the juveniles there, so she would still be kept separated.
Well, this would be if it's sent back. If she's sent back, she would be a ward of the youth court at that point.
Oh, if you're saying if the case is transferred back and
yes.
Yeah, I mean, at that point, she would be considered a juvenile, yes.
Right, and she could interact with people her own age.
Sure.
She could be getting counseling. She could be getting things of that nature. What about her schooling? She would be able to be doing schooling, correct?
She would.
Right. Right now, she has no access to schooling whatsoever. So there are actually programs and benefits about going back to the youth court, wouldn't there be?
Mr. Camp, I want to clarify. If she were adjudicated in the youth court, these would be the dispositional alternatives. One would be 90 days in detention. So for 90 days, not counting the amount of time that she's already spent detained pre-trial. So, and the idea, the meaning behind the statute would be the intent that she can only be detained for 90 days. So, it would be my understanding she would possibly have to be released upon being transferred back because she's already exceeded the 90 days that would be considered for disposition. Secondly, the other alternative would be Oakley Youth Developmental Center. The average stay at Oakley is 6 months, 6 to 9 months, to which she would be released on parole, all of which she could receive some type of counseling. Yes, the question is going to be, is that counseling is Oakley Developmental Center or is the 90-day stay in the juvenile detention center enough to rehabilitate for purposes of the acts that are alleged? My opinion is no.
Now, she could get some help though, correct? That's the only, right now she's not getting any, I guess she's seeing a counselor through Region 8, but there's no schooling. There's no long-term counseling, but you have long-term counseling at Oakley, correct?
Long-term counseling, again, it would be 6 to 9 months. Should she be found guilty in this court, she would have available to her all of the resources that are available to anyone at the youthful offender unit, which would include possibly education and the like. She would have the adult services that are allowed. The question, though, is could she be rehabilitated in the juvenile justice system? Haven't followed her case. I don't have a social summary in front of me. I'm not prepared to make that decision other than based on the allegations of the crime. And those types of things are also considered. It's an A through N survey, and the first 6 or 7 factors of that are going to be the nature of the offense committed. That's a lot to be taken into consideration. When we're talking about charge of murder and attempted murder, those are going to be very difficult to rehabilitate in the juvenile justice system. It's just not built for that.
No further questions, Ron.
No, you're very wrong.
Any further witnesses?
Nothing further, Your Honor.
Any witnesses in reply by the defense?
No, Your Honor.
All right, any further argument by the state?
Your Honor, none other than what's already in our motion, our response.
Any reply by the defense?
No, Your Honor.
The court's going to deny the motion to transfer the defendant to youth court. I appreciate Mr. Gerber's testimony, but the court was very familiar with the inherent limitations of the youth court. That's not a knock on the Rankin County Youth Court by any means, but as this court appreciates it, me transferring this case back basically is an acquittal. I don't think that's an appropriate ruling for a court to make. I believe in juries. And that's what's going to happen in this case. The jury of this community is going to make the decision whether or not to acquit her, whether or not the homicide is justifiable or excusable, or whether or not the state can prove that beyond a reasonable doubt. Those are not questions for a judge. That is a question for the jury. This court will not stand in the way of the jury. All right. State's giving me an order denying the motion transfer back to youth court. All right. We will reconvene here this Friday morning, September 13th, unless I receive an order from the state that no motions are necessary and you're prepared to proceed to trial, or notification to that effect. All right? We'll be back here this Friday morning, September 13th at 9 a.m. Then it will remain in custody. I'll see y'all back there.
And Your Honor, we have one issue that we'd like to take up in chambers with you if we could.
No, Kelly, she did. I couldn't tell if she was upset when they were talking about moving her back to juvenile to the youth court, or when they talked about school. I mean, I would think even if she's in adult facilities, she's still a kid, and they should be giving her her schoolwork to, like, let her learn. They should not. I don't think that's right. I don't. I think they should be helping her. If somebody could help her do her schoolwork there.
Mm.
You know what I mean? She's in solitary confinement anyway. Maybe. I don't know. And some absolutely are. Like Teresa said about Crumbly, nobody listened to him.
Mm-mm.
We don't know the situation here yet to know if something like that was happening. She was on medication, so somebody was trying to do something for her, I believe.
We'll have to wait and see what comes out in the trial, I think, and what they let in.
I hope you're right, Nidawal, that there is somebody looking out for her,
Mm.
or just for anybody
Especially
in her
mental health.
situation.
It's
Yes.
woeful. It's the same in this country. Mental health is not managed very well at all.
And yes, I agree, Kelly. Absolutely. She should be getting education.
Hmm.
They should continue on with that. And I agree with you, Gabby. We talked about that
Oh yeah.
last
Mhm.
week. You
Mhm.
just don't know what's going on in
Nope.
somebody's house
Nope.
ever. I don't care what kind of front they give you.
That I've not read that anywhere near well.
I'm not sure. Man, Flashbang going way back.
Mm.
I don't think we should throw her away by any means. I think we should, if they can help her, try to help her as much as they can. Even if that's not in prison, even if it's like, I think Nidawal said it, I think Flashbang said it, if it's in a hospital,
Mm.
if that's where she has to stay, is in a psychiatric hospital, whatever they're called anymore. At least try. That doesn't mean she gets out. That doesn't mean she, still doesn't pay for her actions. I don't know. I could say I don't know how it is in Australia, Jody. Mental health here is a huge deal, and they
Mhm.
talk about it all the time. My problem, and it's a dangerous slippery slope with it, is like I have a family member. We all know they need help.
Mhm.
They will not stay on their medication because they start feeling better, so they
Yep,
go
they
off
think
of
they don't
it.
need it. Yep.
They think they don't need it, and then they
Mhm.
slide back down,
Yep.
but you cannot make an adult go get help or take their medicine. I mean, unless they're really, really bad or do something really bad.
Mhm.
It's just this vicious circle of,
Yep.
um
And the doctors don't want anything to do with them because, well, they didn't turn up to their last 3 appointments because they didn't think there was anything wrong with them.
right. Like,
Mhm.
and I'm not saying jail is a
Mm.
place where they need to be, but at
No.
least if the jails had more there's a big argument around here right now because the county next door wants to build a new jail, and people are like, "No." I forget what their slogan is, but I'm sorry, like, we need a new jail because jails only have so much life in them, and it's a short one, and they need a new jail. But they do need more mental
Mm.
health help, but getting them they're like, "Just give them mental health help." I'm like, "Well, if they say no,
Mhm.
then what are you gonna do
Yep.
with them?"
Yep.
Ugh,
Mhm.
well, to institutionalize them, Gabby?
Well, look what they did to Karen Reid. Didn't they section her on one report from the first responders? Oh.
Oh, absolutely.
Mhm.
Yes, but you were a minor, Becca. An adult, it's hard to get that same action. It's really frustrating, and I don't know how to make it different because I get
Mm.
really frustrated when they're like, "We need more mental health act whatever." It's like, "Yes, you not saying you don't, but how do you get somebody that won't take it to take it?" So I don't know. What'd you put up here?
Oh, that's a picture of Paris Lee Bennett.
Ew.
Ooh, creepy, evil. Ooh, looking dude.
I will show that in just 1 second. And
Mm.
yes, and Becca, I had a story that I was kind of following up in Wisconsin. I know that'll shock you, of people who had checked themselves in, adults who had checked themselves in to get some help, and then they couldn't get out.
Mm.
So there's that slippery slope too, because that would be scary. All right. Ew.
Yeah. Yeah. Yeah, he nasty. He nasty. Yes, that's a picture of him. But I've got a like an article if you wanted to have a look at it.
Yeah, we just got time to unalive right now. I have to put it in the friendly way.
Yeah. Apparently, they have. This guy was interviewed by Piers Morgan, and it is now a Netflix show.
Yeah, that's what
Yeah.
Becca was saying, but they left out all the essay he did.
Oh, okay.
So good for them.
This is just one article I found. Hang on. I shall share it. Screen.
I mean, I know there's like Becca and Gabby, I know there is stuff that you can do. Like Baker, like Florida has Baker Act. I think everywhere maybe has some form of the Baker Act. But it's hard to get it done in some cases. Like the person I'm talking about wouldn't meet the criteria for it because trust me, I have looked into it. And at the moment, they wouldn't meet the criteria.
Loopholes. Massive loopholes.
Oh, that's in my state.
And who was he?
I'm not sure. I'm wondering if I just don't know the name, but I know who it is. We had a serial. Well, if you're talking kid, Nidawa, I don't. Yeah, Baker Act. There's a oh, he was 19. There's this farm, not far from me, up in Indianapolis area. It's something like Fox Hollow Farm or something like that. And the guy that owned it is not alive anymore, but they have been finding human remains there for years.
Oh.
This guy unalived so many people. Men he was bringing back to this place. And they just have recently, I think, either found some more or they finally have identified some of them. But I mean, forever. Like this guy got away with it and he's not alive anymore. So I guess he got away with it. Becca says the documentary is about whether he should be allowed out now for something he did because he was so young. And the mother supports him, and the mother has another child and wants Paris to have a relationship with her new child for when he gets out. And they totally leave out how brutally he attacked his sister. The documentary on Paris Bennett should be ashamed of itself. You know, that's like not the first time I've heard that about Netflix documentaries. I watched one and I don't remember what it was about. But I knew more about the case, and they did not, like, that's not true. That's not how that happened. I don't have Netflix. Yes, it is very much appreciated for all of you that are using friendly YouTube words.
I think we've been exceptionally good today.
We've done well today. I didn't even say a bad word when Baker scared the crap out of me. Because trust me,
I haven't dropped the F-bomb once.
You haven't.
No.
My heart, for whatever reason, like my heart sank, my stomach like went, oh, what happened? Why are we getting, like, what happened? I was like, are we being attacked? Try to remember that next time I'm in shock. Let me look it up, Becca. I'll see if I can find a picture of it.
That rings a bell. That
I'm telling you, it's like
that
creepy.
Farm name. Why does that ring a bell?
Because that's what I was just talking about.
Oh no,
I'll look it up because that's where the serial unaliver was. But I'm not sure if I have the correct. I know it's Fox something. Yeah.
Hey, Sarah.
Oh my gosh.
Have you been
Sarah.
lurking? Have you been
Look, she-
lurking?
I don't think I watched that one, Flash Fan. Fox Hollow Sailing Star. That's a little different. All right. So, oh goodness, let me just find a picture. It's a huge place in Westfield, Becca, Indiana. And you'd be amazed how many things have Fox Hollow in their name. Yes, you are correct, Sarah. So, oh, come on. Dang it, I don't have Facebook. So there's an indoor pool that's like in the basement down there of this big, huge house. It's creepy. But I don't have Facebook, so I can't. Give me 1 sec. All right, let me show you. What do you got here?
Oh, it's just an article on Paris Bennett.
Oh, I thought you said you came up to Indiana, Becca. Dang it. That would have been.
And it also has a hearing today.
You'll have to read it because I can't.
Oh, sorry. Apparently, he's actually a diagnosed psychopath. And it says a man who is more intelligent, more cunning, and more manipulative than any criminal that this investigator has met before. Netflix has always been a go-to for true crime fans, and it seems Psychopath with Piers Morgan has proved just as popular and is now a trending show on the streaming platform. Crime documentary Psychopath delves into the story behind the heinous crime of a Texan murderer. Past Morgan has introduced his fans. Netflix viewers get to meet Paris 25, who connived his 4-year-old sister to unaliving when he was a teenager.
I'm glad you have to read this.
During the one-off episode, audiences get to watch an interview between him and Paris while he serves a 40-year sentence at the Ferguson Unit, Texas prison. There is a picture of Paris and his younger sister Ella in 2004.
Oh, he looks completely different.
In his first interview, he admits to Piers that the unaliving was driven by a calculated desire to inflict pain and misery upon his mother, Charity. But there is a very unique twist to this show. Charity, Paris's mother, is watching the encounter as it unfolds on a TV monitor in a nearby room. What? And to add an even bigger twist to the tale of this unaliving, unlike many of the American unalivers being interviewed, it is likely that one day Bennett will walk out of prison a free man. The hour-long episode will delve into the story behind this brutal attack, drawing out all of the disturbing facts and responses from the unaliver himself. There's the picture. He's diagnosed a psychopath, murderer, and a genius. 2007, Bennett brutally unalived his younger 4-year-old sister Ella at their home in Abilene, Texas. He was just 13 years old at the time. Despite his diagnosis, Paris has previously claimed he does not suffer from any mental illness. In 2017, he spoke on The Family I Had. Is that a show? And stated, I chose to do my crime and I take full responsibility for my crime. I wouldn't say there was a predisposition to what happened. I'm not insane and I don't suffer from any mental illness. Okay. He has an IQ of 141. He is a psychopath. Every expert that has met him has said he can't be cured. But what he did was a despicable act of evil designed to torment his mother, who hadn't done much to deserve it. She didn't need to do anything. In my opinion, if you were scripting a movie about a young psychopath, you would choose someone like Paris. He's very articulate, well-spoken, good-looking. What? Righto. Cannot be changed. He can be managed, which is why he's in a prison, but it will never go away, in my opinion. He should never get out. On the night of the unliving, both Paris and Ella were being looked after by babysitters. Their mother, Charity, worked at a local bar. He was 13 at the time, told the babysitter to leave before he then went on to attack his sister in her bedroom. First he her, then he her, and then he her, a total of 17 times. Did we get that?
I got it. I can only.
Sorry, I couldn't think fast enough. What?
I can only see, Joey. I can only see from. Yeah, look at
Here
me.
up.
Here up.
Where is it? 17 times.
Yeah, nasty.
After the brutal hang on. According to reports, Paris then spoke to a friend on the phone for 6 minutes before he called the police, who promptly arrived. After the attack, he claimed he suffered a hallucination in which he saw a demonic version of Ella. However, he later stated that it was calculated and he woke up that morning in a clear state of mind. There you go.
Well, Becca, even though I think you should tell what happened, I think they don't want to because she was so little. They don't like to have those details in there. But even though it is what it is, like you can't change it. It's like when we don't get to hear stuff in court or whatever because they think, oh my gosh, our sensitive ears can't take it. It is what it is. So, bad news, folks. They have pushed the start back to 3:30 p.m. I don't care. Well, I do care.
I do.
I normally don't care. It'd be hard for me to start back at 3:30 p.m. because I wouldn't be able to do it.
Yeah,
But
that's 5:30.
yeah, no. Just as we were talking this morning.
I can start early tomorrow if you want.
Yes, we'll just plan on doing that. Do openings and then go till you can.
Yeah, I'll start at well, I'm happy to start at 8 your time, but I'm happy to start earlier if anyone wants to get on earlier. That's
Gabby will
fine with
cry
me.
if you say that.
Yeah, okay.
And I
8
know
o'clock.
Flash
8
Band
o'clock.
that law enforcement doesn't release everything, and I know they can't, and I understand all that. However, this case is done. It's been tried. It's obvious that that's out there. You know, so this would be Gabby if you said 7 a.m. That might be me too.
You don't have to come on. I can start at that time if people want to watch it, but yeah, I'm happy to start at 8. That's fine. No problem.
I mean, that's up to you.
No, that's good.
You said it. I will set it too. uh, I'm looking. Becca, I've not watched any of that trial except the judge. It was horrible. And
WLBT hasn't got it scheduled until lunchtime tomorrow. And that's the local station.
Huh. Well,
So
who's doing the YSL? Who hasn't given up on that yet?
the Nick Darrow.
Yeah, when he said, I'm going to do this, it's going to take like 3 months, thought, or 6 or 7 or a year.
I thought they shut that down over something.
It keeps getting shut down. See, oh, that's
yeah, I reckon so, Flash fan. I don't
see you,
I
Kelly.
think you're guessing.
We'll be here tomorrow.
See you, sweetheart. Set your notifications to all.
Have a great day. Yeah. Yep.
And,
yeah,
you know,
they've shut that trial down like 100 gazillion times. And then they I don't know. Never mind, they are on a break. That could be a 10-minute break, a 20-minute break, a lunch break, a week break, 3-month break. All right, guys. I think I'm going to shut her down.
Yeah.
I don't have anything else to do.
No,
and I know Jody needs to go to bed.
Yeah.
We had a discussion about her getting sleep this morning. I didn't have to use my mom voice, but I will.
And I hope Bri passed his advanced life support skills too
yes,
today.
Me too. I told him that was a little more important than our stream.
Absolutely. Bye-bye, all. Thank you, Gabby.
Thanks,
Thank
Gabby.
you, everyone.
Thank you, everyone that
It was
here.
Lovely. Hanging, chilling.
Thank you, all the Bakerators, for scaring the crap out of us. At least me. I don't know. Maybe you didn't scare Jody, but it did caught me way off guard. So when Baker raided us.
Oh, I didn't.
Because I looked over, like we had like, I don't know, 14 people or something I was looking at. And then I looked back over and there was 45. I'm like, what is it? That can't be right. One day. But I was like, what happened? Who's coming? Somebody's coming to get us.
Excellent.
Bye, Debbie.
Excellent. We should start doing that too, like checking who's online and just redirecting just as a for shits and gigs, really.
I don't think he is, though.
No, anyone.
I would ship back to him. I asked them all Friday if they wanted me to redirect over to him.
Friday
and everybody
was a long
said
day.
no.
It's been a long week of watching crap.
They were just like, we're tired.
In the courtroom.
We want.
I think everyone crashed Friday.
Don't love him, but they just were not about it.
Don't know why.
That was horrible. Gabby, I was over it. I know you were, Gabby. Yeah, we got you. Yeah, we got Gregg trial. And then Grandma, but I don't think Grandma's live. right? She's not there. That's just her screen up.
Oh, she might be running Wordle or something, maybe. I think she's got a few coming up this morning. I've got my notifications on, but I think they're in the morning, or my morning. Your evening.
She is doing live Words with Friends because I can dump you all over there. You're going to go there anyway.
Yeah. Yep.
Oh,
Right, Grandma. Right, Grandma.
Okay, she's not there though.
Yeah.
She's not on the screen. Okay, so she wouldn't
Okay.
know.
All right, streaming. There you go.
Yeah, he'd be like, "Who is alternate juror?"
Doesn't matter.
I can't
Every
see
time you
him.
do it, he'll remember.
I can't see him. Are you sure you can't?
I can't. No, I can't do it until I am monetized, which won't be that long, I don't think. I think by this week I will definitely have met 2 of the 3, and it's just a matter of I think about 80 subs, and I'll be there. I'll be done.
Really? Wow.
Yep.
All right. Well, I'm gonna dump you guys over into Recovery Addict stream. So please,
Sorry, 180.
at least I was like, okay, well, you
Yeah,
got a
no.
lot since I saw
Yeah,
it
no,
this
180.
morning. But
Brain.
everybody's numbers are different, so I
330.
don't say anything. Please
Yeah.
say hello to Recovery Addict because he's gonna be like, who
Yay!
is that?
Today's coverage of law and crime. And it doesn't work like that, unfortunately. I wish. Otherwise, I'd be rich. I'd be on Tats Lotto and I might go and watch it in bed.
All right. Well,
Okay.
there you guys go. Thanks,
Mwah.
everyone. Thanks, Gabby,
Mwah.
for modding
How's it go?
everything. Thanks, everyone, for visiting. Make sure that you have your notifications turned on because Jody's going to start whatever time Jody wants to tomorrow.
It'll be 8. It'll be 8. I'll be nice. It'll be 8.
Fine. All right. So we shall see
Love
you
y'all.
guys in
See
the
you tomorrow.
morning. Bye.
Bye.
Jody and Debbie here. Fill your screen with cheer. Hit like and tap subscribe. Join our happy tribe. Thanks for watching now. Hope you had a great wow. Come back very soon. Join us on